Good morning. The Judiciary Committee will come to order, and without objection, the chair is authorized to declare recesses of the committee at any time. We welcome everyone to this morning's hearing on data stored abroad, ensuring lawful access and privacy protection in the digital era. I'll recognize myself for an opening statement. Today's hearing will examine various issues related to digital data, including international conflicts of law, storage and transmission practices, governmental acquisition challenges, and protection of consumer information. This hearing brings together a diverse array of interests, including law enforcement, technology companies, the economy, and the importance of individual privacy and civil liberties throughout the world. In the digital age, U.S. technology companies have flourished and provide services to customers across the globe. However, the rapid growth of international communications infrastructure has presented challenges as well as opportunities. For example, there is a growing tension between U.S. law and foreign law, often with U.S. technology companies at the center. U.S. law restricts access to data by foreign countries, making it difficult, if not impossible in some instances, for foreign governments to obtain evidence of crimes or terror plots carried out by their own citizens. This has resulted in foreign governments enacting their own legislation to address the problem, including laws requiring U.S. companies, as a prerequisite for doing business, to comply with foreign government requests for data. Others are considering legislation that would require U.S. providers to locate servers in the foreign country to ensure foreign jurisdiction over the U.S. provider. This is sometimes referred to as data localization. Moreover, certain foreign countries prohibit the removal of data from their boundaries. U.S. law, by contrast, makes no distinction between data stored domestically and data stored abroad, nor with regard to the nationality or location of the customer. The result of these conflicts is that U.S. technology companies find themselves having to comply with either U.S. law or foreign law, as it is often impossible to comply with both. This is an untenable situation. The last time this committee considered these important issues was prior to the Second Circuit's 2016 decision in Microsoft versus United States, where the court ruled that the Stored Communications Act does not authorize courts to issue and enforce against U.S.-based service providers warrants for the seizure of customer email content that is stored exclusively on foreign servers. Microsoft had refused to comply with a search warrant for email content on the basis that Microsoft stored the email data on a server in Ireland rather than in the United States. In the wake of the Microsoft decision, other providers have refused to comply with warrants on the basis that some or all of the data pertaining to the subject of an investigation is stored on servers located outside of the United States. In the courts, however, 5 recently issued opinions diverge from the Second Circuit's ruling, concluding that data must be disclosed pursuant to lawful process, regardless of the location of the data being sought. It is clear that Congress must find a contemporary solution that embraces the modern manner in which data is stored and acquired internationally. A legislative fix to the Stored Communications Act is necessary to remedy the problem made clear by the Microsoft decision. Furthermore, Congress should take additional steps to resolve the conflict of laws issues. Various options exist on this score. A formal multilateral treaty could result in broadly raising international privacy standards to more closely match the United States' rigorous probable cause standard and would comport to the founders' insistence that broad international agreements affecting many parties require Senate consent and ratification. Another option is bilateral agreements. The United States and the United Kingdom are currently engaged in negotiations on a bilateral agreement that would authorize the UK government to request data directly from U.S. companies in criminal and national security investigations not involving U.S. persons. To ensure clarity on this point, any international agreement that provides access by a foreign government to communications stored or flowing through the United States will not authorize that foreign government to wiretap or target U.S. persons or those located in the United States. This restriction applies even to our closest ally in the United Kingdom. Such an agreement could only be used to obtain evidence on non-U.S. persons located abroad. The potential U.S.-UK bilateral agreement may serve as a model for future agreements, relieve some of the international pressure on U.S. tech companies, and help to alleviate any conflicts of law relating to requests by the U.S. for data stored abroad by U.S. companies. In order for an international agreement of this kind to take effect, Congress must first change U.S. law to grant specific authority for U.S. companies to respond to direct requests by foreign authorities and prescribe the criteria that must be met by the foreign government. These are not the only options available to Congress. In addition, there are legislative proposals that would attempt to resolve conflicts by basing the authority to obtain information on the nationality of the targeted individual. The committee will continue to explore all of these aforementioned options. Once again, House Judiciary Committee finds itself at the forefront of a pressing issue that impacts personal privacy, national security and public safety, economic viability, and the rule of law. Members of this committee will continue to examine all options for a thoughtful and balanced resolution to this problem. I appreciate our distinguished witnesses testifying today. I want to particularly thank one of our first witnesses, Mr. Patty McGinnis, for agreeing to travel to our country during such a difficult period in the United Kingdom, which has suffered multiple terrorist attacks in recent weeks. We greatly appreciate your presence and your vital perspective on the challenges with new forms of digital data storage and transmission. I want to thank all of our witnesses, and I look forward to their testimony. And I now turn to the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
I thank you, Chairman Goodlatte, to our colleagues, and to our distinguished witnesses in the first panel. It seems we keep returning to the same theme. The statutes that protect our privacy and regulate government access to our communications were written decades ago, before the invention of the internet, and are in urgent need of an overhaul. Under your leadership, Chairman Goodlatte, we have already worked together to address one aspect of this problem. The Email Privacy Act has passed unanimously in the House twice. And that measure allows us to move to a clear, uniform domestic standard for law enforcement agencies to access the content of communications, namely a warrant based on probable cause. There's no reason that the Senate should not pass the same bill that the House has approved in the past, so that we can turn to the important work before us on additional related issues without delay. In this hearing, we'll examine a framework that seems inadequate to the 21st century. Our existing system of mutual legal assistance treaties and the overseas application of the Electronic Communications Privacy Act. The Mutual Legal Assistance Treaty system was written for a different era, quite frankly. I agree with the long-held view of the British government that it's absurd for a police officer investigating a routine crime in London to have to wait months, sometimes years, to access digital evidence stored in the United States, evidence that relates entirely to their citizens and not to ours. I also agree with the Department of Justice that we are now facing a reciprocal problem. The recent decision of the Second Circuit appears to limit the application of the Electronic Communications Privacy Act to the United States, which means that while investigating crimes in the United States, even with a warrant, our government may not be able to access communications that are now stored around the globe. These are both real problems, and I believe that Congress should act quickly to update our statutes accordingly. But I also believe that we must carefully evaluate the administration's legislative proposal. For example, I am not convinced that simply reversing the Second Circuit solves the problem presented to us by the Microsoft decision. We should address law enforcement's need to access the content of communications with proper legal process. But a straight reversal does little to address the challenges that face companies operating internationally or to accommodate the interests that foreign governments may have in protecting the privacy of their own citizens. We can achieve a better balance here. Similarly, the proposed bilateral agreement framework is full of promise, but only if we get the details right. Implemented correctly, these agreements could counter the trend toward data localization, incentivize our partners to set better standards for data protection, and help our closest allies investigate serious crimes. I'm not yet convinced, however, that we have landed on the right criteria for determining which countries we should partner with under such a framework and under what criteria. I understand the need to be flexible in order to accommodate different legal regimes, but too much flexibility renders the criteria meaningless. I'm also not yet convinced that it's necessary to give foreign government access to live wiretap information as part of a package that focuses largely on stored communications. Finally, it's imperative that both the Congress and the public have a meaningful opportunity to comment on these agreements before they take effect. Under the administration's proposal, the Attorney General is to give Congress notice 60 days before he or she intends to give a foreign government access to communications stored in the United States. The proposal includes no mechanism for Congress to respond or for the public to weigh in before the new agreement takes effect. I'm certain that we can do better to ensure confidence in the decisions of the Department of Justice. I appreciate that time is of the essence and that this committee, the Judiciary Committee, must begin grappling with these issues without delay. I'm confident that working together, we're prepared to do so. And I thank the chairman for convening this important hearing, and we're ready to go. Thank you.
Thank you, Mr. Conyers. Without objection, all other members' opening statements will be made a part of the record. We welcome our distinguished witnesses, and if you would both please rise, I'll begin by swearing you in. Do you and each of you solemnly swear that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Let the record show that the witnesses answered in the affirmative. Mr. Richard Downing is the Acting Deputy Assistant Attorney General in the Criminal Division of the Department of Justice. Previously, Mr. Downing served as Deputy Chief of the Computer Crime and Intellectual Property Section of the DOJ. During his tenure there, he supervised the prosecution of hacking, identity theft, and intellectual property crimes oversaw policy and litigation governing the constitutional and statutory rules for the collection of electronic evidence, and supervised the development of international law enforcement cooperation related to cybercrime and intellectual property crime. Before joining the Department of Justice in 1999, Mr. Downing served as an assistant district attorney in Philadelphia. He is a graduate of Stanford Law School and received his Bachelor of Arts from Yale University. Mr. Paddy McGuinness is the United Kingdom's Deputy National Security Advisor for Intelligence, Security, and Resilience at the Cabinet Office. In this role, he supports the Prime Minister and National Security Advisor on all aspects of counterterrorism, cybersecurity, national resilience, and crisis management and security policy, as well as the governance, resourcing, and policy surrounding the UK's intelligence agencies. Mr. McGuinness has had an expansive career in foreign service since joining the Foreign and Commonwealth Office in 1985. He has served in Yemen, the United Arab Emirates, Egypt, and Italy, holding leadership positions covering the Middle East, counterterrorism, and all aspects of cybercrime. Mr. McGuinness attended Ampleforth College and the University of Oxford. I want to, again, thank the witnesses. Your written statements will be made a part of the record in their entirety, and we ask that you summarize your testimony in 5 minutes. To help you stay within that time, there's a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 5 minutes have expired. And Mr. Downing, you may begin. Welcome.
Good morning, Chairman Goodlatte, Ranking Member Conyers, and members of the committee. Thank you very much for the opportunity to testify on behalf of the Department of Justice concerning a significant impact on public safety and national security. We are unfortunately living in a world where criminals, both in the US and abroad, prey on Americans. Cybercriminals steal our intellectual property and empty our bank accounts. Terrorists threaten us with brutal attacks, and pedophiles seek to sexually exploit our children. Never before have we had as great a need for access to electronic evidence in order to solve crimes, bring criminals to justice, and to protect public safety. Today, U.S. communication service providers often store customers' data, including the data of American customers, in data centers in foreign countries. Some providers constantly move that data in and out of the United States and around the world, sometimes minute by minute, for business efficiency and other purposes. It is against this backdrop that I want to deliver two important messages. The first is this: the rule announced in last year's Second Circuit decision in Microsoft v. United States is undermining the public safety of the American people. We believe the case was wrongly decided. That decision and the choice by major U.S. providers to apply its holding across the country is preventing effective and efficient access to critical evidence where the provider has chosen to store that data overseas. And the remarkable thing is that it sometimes prevents us from using a warrant even where the crime, the victim, the offender, the account holder are all inside the United States. These developments are affecting law enforcement efforts in just about every kind of case that we investigate. Let me give you a couple of examples. In one case, a U.S. defendant was arrested for sexually assaulting children, and a search warrant was issued and served on Google for the content of that defendant's account. Google did not produce the photo attachments in that account, and investigators need those photos in order to identify and locate other child victims. In a drug trafficking investigation involving targets in the United States, Canada, and China, a search warrant was issued to Microsoft. Microsoft did not produce any email content. Investigators need that content to identify the members of the drug trafficking organization. We need swift action by Congress to correct this problem. The department recommends a clarifying amendment that would explicitly require providers subject to the jurisdiction of the United States to disclose data pursuant to legal process, no matter where the provider has chosen to store the data. This brings me to the second message. This amendment should be passed as part of a package that would also improve cross-border access by foreign law enforcement to data stored within the United States, a so-called US-UK framework. We are, of course, not alone in facing challenges in protecting our citizens due to the globalization of the U.S. communication service providers. Our foreign law enforcement partners also face obstacles in obtaining electronic evidence stored outside their territory. Increasingly, those countries have issued their own legal process for evidence from U.S. providers. And at times, the providers have to decide whether to follow the foreign laws and obligations or the restrictions on disclosure found in the Electronic Communications Privacy Act. That's why a group of large U.S. providers came to the Department of Justice and asked us to help develop a new bilateral framework for cross-border data access. These U.S. providers want to be able to comply with foreign court orders without violating U.S. law in situations where the U.S. interest in protecting the information from such disclosure is at a minimum. Consider the investigation of a homicide in the UK. Scotland Yard opens an investigation, questions witnesses, searches houses, seizes phones. Everything to do with the case, the victim, the crime, the suspects, is in the UK, except, that is, for the victim's email and social media accounts, which are stored in the United States. It's pure happenstance that the data is stored here, and there is no meaningful U.S. nexus to the case. This is a prime example of where it makes sense for UK law to control. Congress should enact legislation to lift the restrictions in U.S. law where a bilateral agreement exists between the two countries. We have explored how such an agreement would work with the UK, and if the approach proves successful, we would consider it for other like-minded governments who respect the rule of law and have robust privacy safeguards. Thank you again for the opportunity to testify on this important issue, and I look forward to answering your questions.
Thank you, Mr. Downing. Mr. McGinnis, welcome. We are especially pleased that you have made a long trip to be with us today to testify about the importance of this issue. So welcome.
Chairman Goodlatte, Ranking Member Conyers, members of the committee. It is an honour to appear before you on behalf of Her Majesty's Government. Before I turn to the substance of my remarks, I'd like to express my sympathy for yesterday's shocking attack against this Congress, its staffers, friends, and your police service. We wish Congressman Scalise and all those injured a speedy recovery. They and their families are in our thoughts and prayers. It is a symbol of the resilience of this House that you are pressing ahead with business, and tonight's baseball game as well. I had the honour of appearing before the Senate Judiciary Committee on the 24th of May, 2 days after the cowardly attack in Manchester, which killed 22 people and injured many more. I now return to Congress in the wake of the attack on London Bridge on 3rd of June, during which 8 innocents were killed and 48 wounded. 5 other attack plots have been foiled since our Parliament at Westminster was attacked on the 22nd of March. Put simply, the scale of the threat against the United Kingdom, its citizens, and the foreign citizens who live there is unprecedented. It is a matter of pride to us that we are resilient. We reacted fast to the attacks and have quickly returned to normality. Manchester and London are safe and open for business. But our returned Prime Minister has also caught our mood when she said, "Enough is enough." That is why she sent me to appear before you today to explain why Congress should, in our view, amend US law to permit a bilateral agreement on data access. As Deputy National Security Advisor, my responsibilities are made more complex by a world connected by the internet. Serious crimes like human trafficking, child sexual exploitation, drug trafficking, and money laundering do not respect borders. A British citizen who has joined Islamic State can cause untold havoc through a cellular phone, a laptop, and a Wi-Fi connection. I am not a lawyer, but I know that we share an extraordinary legal heritage derived from the common law with respect for freedom of speech, privacy, and the rule of law. Law is the bedrock of our mutual prosperity. It has enabled America's ingenuity and entrepreneurial spirit to flourish, and us all to benefit. Nowhere is this more evident than in the success of American technology companies. And the people of the United Kingdom are amongst the most enthusiastic users of the services of those companies. Unfortunately, through no fault of the companies, that includes criminals and terrorists. Today, a British police officer investigating serious crimes taking place in London can get a warrant for the communications between criminals. If those criminals communicate using the services of a UK company, that warrant can be executed, the crime investigated, and citizens kept safe. When those same criminals communicate, as 90% do, through an American tech company, the current law of the United States can prevent that company from providing the content of those communications to the UK police officer. Crimes go on with the criminals unpunished as a result. This cannot be right. It is arbitrary. It places US companies in an impossible position, stuck between the laws of two close partner countries. It constrains law enforcement, and it makes us all less safe. The need to resolve this is urgent. That is why I've come before you today to ask that you make a technical adjustment to US law to remove the restriction on US companies providing data in tightly defined circumstances. This will enable a UK-US bilateral agreement to be signed. You will rightly be concerned, as our lawmakers have been, that privacy, freedom of speech, and other freedoms be protected. Let me therefore make clear what this proposal is not. It is not an expansion of UK investigatory powers. It does not impact the privacy rights of US citizens and residents. Any agreement would not permit the UK to target US persons or anyone in the US. It is not about encryption. It is entirely encryption neutral. It is not about obtaining communications in bulk. The orders under an agreement would be for individual targets. It's not compulsory. It simply removes the current legal bar to US companies responding to UK orders. It is not one-sided. It is reciprocal. The new UK law permits US use of an agreement's provisions in the UK. This present conflict of laws is unsustainable. Some countries are requiring data to be stored in their territories. Others are arresting or threatening US company employees. This is not good for our mutual prosperity or security. Now, Congress has the opportunity to create a solution and set the standard for transparency, privacy, and legality for the rest of the world to follow. I thank you for the opportunity to appear before you today. I look forward to answering your questions.
Thank you, Mr. McGinnis, and I'll begin the questioning under the 5-minute rule. Mr. Downing, the Department of Justice is engaged in talks with the UK government about a bilateral agreement that would allow the UK government to go directly to US technology providers to obtain stored data such as emails or to serve wiretap orders for real-time intercepts of communications in criminal and national security investigations not involving US persons. Why is this necessary?
This sort of agreement has a number of benefits. We've already touched on some of them in a variety of different ways. It's very important for us to help our colleagues and allies to solve the domestic security problems that they have, and it also helps the US companies to make sure that they're avoiding any conflicts of law. It reduces incentives for data localization and creates incentives for countries to raise their own standards of protecting privacy and civil liberties. And as has been mentioned, it's very important that we have the ability to get access to data in foreign countries for our needs when that data happens to be stored there in appropriate cases.
Is a formal treaty instead a better mechanism that would raise international standards more broadly while accomplishing the stated goal with multiple signatories at once?
It's an interesting question about what the correct or the best mechanism would be for accomplishing this kind of a goal. Let me begin by saying, though, that we very much expect that we would have close collaboration with Congress as we begin to think through these questions, to work with the UK and potentially with further countries down the road. But we also have to think about how it would be most efficient in order to be able to build out this idea to further countries as well. We think that the proposal that we put forward really does accomplish a good balance there. It has a very strong role for Congress at the beginning, of course, by setting up the rules, the baseline, the requirements. And then, of course, as was mentioned, there's an additional role in the back end where Congress would be notified before anything was entered into. And, of course, that would give an opportunity for Congress to weigh in at that point if it chose to do so. So we think that a bilateral executive agreement rather than a treaty is probably a more efficient and effective way to get the job done and to help all the benefits that I just mentioned.
Thank you. Mr. McGinnis, under the bilateral proposal, there would be absolutely no bulk collection of data and no investigations of Americans. Is that correct?
Absolutely.
And what mechanisms would be in place to ensure that Americans' privacy is protected, while also allowing for lawful access by British authorities to British citizens' email content that resides in the United States?
So, in order to protect US citizens, we should be clear at the outset, and US persons should be clear at the outset, that this agreement specifically excludes US citizens and anybody in the United States. And that is not the purpose of the access to data, so that is excluded. We have equivalent high standards to the United States in the way in which we oversee and manage interception of communications. We monitor closely what is being done, train, study, and have oversight regimes, which means that we have a degree of confidence in what we're able to do. Having said we will not, even inadvertently, intercept the communications of Americans, we're confident that we can put in place systems and processes that will protect their rights.
What's the standard that British authorities must meet in order to obtain the email content of British citizens in the United Kingdom when the content resides in the UK?
So we have a concept that we use, which is established and proven and tested in judicial process in the United Kingdom, which is necessity and proportionality. This is a high bar for gaining access. Necessity relates to statutes, so there are only certain statutory reasons why you might be able to gain access. That would be national security, serious and organized crime, threats to economic well-being, so those will be covered. Certain restricted set of organizations can apply for warrants to intercept communications. Necessity means also that the individual or entity being targeted, there must be a basis for targeting to them. So they must have been in dialogue with Islamic State. They must have come up in searches relating to child sexual exploitation or whatever it might be. And then we have proportionality, and proportionality tells us that we must use the least intrusive means to enable the investigation. And if a less intrusive means is available, we should use that. So it is possible that you will have a necessity justification, but proportionality will mean that a warrant is not agreed. And proportionality is a critical concept when we have judicial review of these warrants.
And how often do British authorities face obstacles to obtaining lawful access to information held by U.S. companies when conducting investigations?
So as I said in my opening statement, there's an enormous penetration of the British market by US tech companies. Everybody, myself included, makes extensive use of multiple platforms apps when they wish to go about their daily life. What that means is, in almost every case that we look at, there's extensive use by the target of investigation of US applications provided by US companies. And that means that in almost every case, there is a basis to ask for, potentially to ask for data if that particular communication use is relevant.
And finally, could you explain the new judicial system in the UK under the investigatory powers regime? In which ways did passage of the Investigatory Powers Act strengthen and bring more accountability to the UK's judicial system?
Certainly. So in everything I say today, I'm going to be talking about the system that will operate under the Investigatory Powers Act, which you've mentioned, which was passed in November 2016. They're being introduced through this year progressively, and that's what I'll be talking about. We're having a double lock. So an intercepting agency, the police service, the security service, will write a warrant. They will submit it to a minister, a senior minister, a certain defined set of senior ministers, who will either agree or disagree with the warrant. If it is agreed, it then goes to a judicial commissioner, and that judicial commissioner will review the warrant, in particular on these issues of necessity and proportionality, but also the public interest in privacy and the need to maintain the security of telecommunications systems, and if satisfied, will also sign the warrant. So what you get is a double lock. The minister signs it, and then the judge signs it. And if either of them refuse, if the minister refuses, it doesn't go to the judge, and if the judge refuses, it doesn't go through.
Thank you. The gentleman from Michigan is recognized.
Thank you, Mr. Chairman. If you don't mind, Mr. Downing, I'm going to ask one question of our visitor and guest here. Welcome to the Congress, to the House Judiciary Committee. We're honored that you will travel as long as you did to join us. And I wanted to just ask you, one criticism of the administration's proposal is that it does not reflect one of our legal traditions, that warrants should issue only with probable cause. I understand that the British system works differently, but would there be a problem with tightening the reasonable justification standard reflected in the current proposal, in your judgment?
So thank you for the question, and indeed thank you for hearing me today. The British Parliament passed the Investigatory Powers Act in November 2016 with a very large majority. It is more than bipartisan, and it is very much the will of the British Parliament. This is the way in which we should manage intrusive powers of this kind. It is founded on established British legal mechanisms, whether that be judicial review or necessity and proportionality. It was considered on the floor of the House of Commons whether or not we should introduce a new and different standard. A new and different standard, and it was concluded that a new and different standard would contain risk because we could not be sure how it would be implemented, and it would not have been tested as necessity and proportionality have been tested. So I think my answer to you is we have very high standards in the United Kingdom. We come from the same legal rootstock that you do. And we have established protections for freedoms, for privacy, for freedoms of speech. And that's at the very heart of British life. And we have legal mechanisms that are proven to deal with that. And those are the ones that should apply to any application for data.
Mm-hmm. Thank you. Turning now to the Department of Justice Representative, Mr. Downing, and thank you for your cooperation. Let's compare two different proposals to solve the problem presented by the Microsoft decision. The International Communications Privacy Act, as introduced by Mr. Marino, which allows the government access to communications stored overseas, but also requires the court to consider the nationality of the targeted user, as well as any concerns our allies might register about the privacy of their own citizens. It recommends a simple reversal of the Second Circuit. Why should we simply reverse Microsoft? Does it matter that litigation is ongoing? And should we not make some accommodation for our foreign partners?
Thank you very much for the question. We believe that a clean reversal of the Microsoft decision makes the most sense because of the very real and significant harms that are being caused by that decision along the lines that I've outlined already. Litigation is ongoing. That's actually a symptom of the fact that we feel very strongly about this and the significance of the problem. We are seeking every means that we have available to try to get that situation solved, including in the courts where we have that right to bring those cases. And of course, that's why we propose to Congress a way of fixing it. To your last question, what is the issue with respect to notifying foreign governments? There's a number of aspects to that situation that I would highlight for you. First of all, it's extremely unusual that we would notify a foreign government when we take investigative steps against one of their citizens. We might search the home of a Russian organized crime figure or a Mexican drug dealer inside the US, and we wouldn't give them those governments notice. And we wouldn't do it even when we did use a mutual legal assistance treaty request. So if we sought information from France, about a Spanish citizen, we wouldn't turn around and tell Spain that we had done that. But more practically speaking, there are a number of concerns that we have about a system of notice to foreign governments. We're concerned about notifying a foreign government which might tip off the target of the investigation. It doesn't make much sense to notify the Chinese about a Chinese hacking investigation that we're doing, or a Syrian terrorist about a terrorist investigation. We're concerned about the reciprocity. Are they granting the same rights to Americans? Doesn't make much sense to give rights to foreign citizens that they are not willing to give to us. We often don't know the nationality of the target. So how do we deal with a situation where somebody is distributing child pornography but using the anonymity of the internet to prevent it? And perhaps most importantly, we need a system that's going to work swiftly and efficiently in order to get us the evidence that we need in order to protect Americans. So a lot of steps and confusion and notification and delay is not what we would favor in our position.
I thank the witnesses, and I thank the chairman.
Thank you, sir. I'll now recognize myself for a round. I picked up on your statement you didn't think we should have a treaty. We have an extradition treaty with the United Kingdom, right? Mr. McGinnis?
Yes, you do.
And why is this not an extradition of an asset, of an entity? Why is it so different, particularly when our laws are not harmonized and not likely to be harmonized as to privacy?
So the reason why we have come to this is because of an important dialogue. And
No, that wasn't the question. I apologize. The question is, why not a treaty? The bar is higher. The standard is higher. It has to be ratified. But, you know, there are about 214 ambassadors, but let's call it 194 countries that the United Nations more or less deals with, 80 or so of which we have no extradition treaties with. So slightly more than half the world has, at least relative to the United States, has agreed to a procedure for extradition. And I'll just briefly go through Mexico. In Mexico, we waive the death penalty when we want somebody who has fled, who is accused of a capital crime. We waive it in order to get them back. It's part of our treaty process. So when we look at the likelihood that the European Union and Britain collectively and now separately will have different standards sooner or later, always almost, in some way for the nuances of how you have to treat data, both of US persons and British persons, aren't we in a situation in which a treaty is a better binding and more appropriate bilateral agreement? And I don't want to belabor it, it's the Senate's job, but you know, is there any particular justification other than yours not doing a treaty is quicker and easier?
So I don't believe this is analogous with extradition. It's absolutely not that.
Okay, well, let's go through that. The data that is being sought can put somebody in the gas chamber in this country. The data being sought can cause people to be asked for extradition. Often the information that is being looked for will lead to extradition. Why is it that data, let's put it this way, the Fourth Amendment looks to unreasonable search and seizure. It's a specific, and it has the same power as the other 9 in our country. So when I look at these inherent protections, and I'll get past treaty for a moment, but when we look at a bilateral agreement of any sort between our two nations, you're going to want to protect British persons at a level that you specifically protect British persons. And we're going to want to protect US persons at a level that we want to protect them. And then we're going to agree based on disparate standards in all likelihood that we're going to exchange data under certain circumstances, correct?
Sounds right.
And you did a great job of explaining in detail how you would come to produce this subpoena or warrant and send it to us. But I can tell you from this committee that there are processes in this country that are virtually invisible, that are done administratively, that could lead to a request for data that currently we're not comfortable with sometimes in the US. So let me ask you a real question. Britain and the United States couldn't be closer probably than any other 2 countries when it comes to our general view of what's right and wrong in the world. But aren't we held to whatever we do between our two countries to be, if you will, the form, the block on which we're supposed to build other bilateral agreements? And so when I look at nations like Cuba, North Korea, Afghanistan, the list is long, that we don't have extradition with, what am I going to do when they want data for their persons? How am I going to look at countries who do not necessarily have the same standards and the same rule of law, and yet will insist that they've gone through a process and I need to give them the information they want?
If I may, you're going to hold them to the very high standards that are proposed in this proposal that have come to you here in Congress. And I long to see the day when in North Korea or Cuba or any of the states you mentioned, they have the kind of protections that you have in the United Kingdom. So this absolutely is a mechanism for leading states along the road. And I would observe that one of the drivers for the revision of judicial oversight of our warrant treaty, where we had a different system prior to the November 2016 Act, was the fact that we knew that it would satisfy the companies who are advocates of this agreement and the United States. So
by the way, the Vatican is on that list that we don't have extradition with. I'll close by saying I'm deeply concerned that we do have to be cognizant that with 80 countries that we can't agree to extradition with, the question of whether those 80 countries, if we fail to reach a more common standard, one that we could reciprocate with everyone on, they're going to tend to say, geez, it's a wonderful world. We want our data located in our country, and it will be an excuse for China, Libya, the Vatican, to each have their own servers. And although I trust the Vatican's business model is such that the server data will be limited, I cannot say so of China. Thank you. And we now go to the ranking member of the Intellectual Property Subcommittee, Mr. Nadler.
Thank you very much, Mr. Chairman. Mr. Downing, before I get to the specifics here, I want to have a couple of preparatory questions. It's been reported recently that it is now the policy of the executive branch not to answer questions from minority party members of Congress on any subject whatsoever and to routinely ignore them. So my question is it the is it the policy of your department, the Department of Justice, not to respond to congressional inquiries from Democratic members?
I'm afraid I don't have an answer for you either way on that. I don't know whether that would be binding on us or where our position is on that.
If the gentleman would yield,
sure.
I'd be pleased to say that, in fact, in parliamentary systems, including Great Britain, the minority right is extensive.
I'm glad to hear that, but I'm concerned right now with a congressional system designed by Mr. Madison. Mr. Downing, if I ask you a question today, which I will do in a moment, you will presumably answer it.
I will.
Thank you. But if I put the same question in writing and send it to you, will you answer it?
I will do my best to answer all of the questions for the record that come forward from the committee.
Despite what we hear is the new policy of the administration?
As I said, don't have a strict answer for you on that particular question.
Okay. Let the record reflect that that wasn't answered and that is very disturbing, that you cannot answer the question in the negative, to put it mildly. Let me ask Mr. McGuinness. You described the system in Britain of proportionality and necessity. We have the system of probable cause. Could you tell us how they would differ in a given case? I mean, how you would look at proportionality and necessity in a different way than we might look at probable cause? I mean, what's the practical impact of this?
So, as I said in my opening statement, I'm not a lawyer, and I'm certainly not an academic lawyer, and my ability, frankly, to compare between different legal systems and the standards within them is somewhat limited. So I'm going to just reflect that necessity and proportionality are a very high standard, analogous, I believe, to much that is in probable cause, and certainly established in the British legal system and a basis for testing and sometimes refusing proposals for warrantry and for action by the state.
Well, since you're not a lawyer, I cannot ask you the next question, which I will simply state for the record as a matter of curiosity and that is what happened to probable cause in British legal history, since I thought it was there in the 1760s, but we'll worry about that at a different, at a different time. I am concerned the proposed legislation would allow foreign governments to request from assistance from the U.S. providers to intercept communications in real time without requiring compliance with Wiretap Act standards. Mr. Downing, could you comment on that and the implications of that?
Absolutely. I think it's important to start with a baseline that has been discussed. These kinds of orders would not be targeting U.S. persons. So you've got to picture the paradigm case here is there's an...
Excuse me, it would not be targeting, but if information was collected on U.S. persons, that could be given back. It's a Section 702 problem.
It is possible that U.S. person information could be intercepted, but let me just, if you think about the paradigm case of a organized crime boss who's setting up a hit and is talking to people and the UK needs that information, it's pure fortuity that the data happens to be stored in the U.S., and so the U.S. interest in that, the application of our law is at a minimum. Nevertheless, the agreement that we have proposed would create strong baseline rules. There have to be articulable and credible facts and particularity, which are ideas which are another way in some ways of saying probable cause. There have to be the exhaustion of alternatives, this necessity idea. It has to be for a limited duration. So all these things are in play, and I think it's important that we understand that there are real restrictions as well. And I think, if I may, one final point, the UK, like the US, believes that wiretapping is a critical part of being able to protect our public safety. If we don't address this problem as part of this...
Yeah, we've clearly got to address the problem. I'm just looking at the standards. In my little time left, might you be better qualified to answer the question I asked Mr. McGuinness about the difference between the British concepts of proportionality and, what do they say, proportionality and...
Probable cause?
Well, proportionality and necessity on the one hand versus probable cause on the other?
I'm afraid I'm, of course, steeped in the U.S. legal system and not so much on the U.K. side. However, I would agree with Mr. McGuinness that I think those ideas achieve the same kinds of goals. They need to be real problems, real faced with proportional consequences. They're analogous, if not identical. But I do think it's important to recognize that we can't have a system where every country has to have exactly the U.S. rules, or we're never going to get anywhere with this. It's important that we have baseline rules, that everybody is respecting of privacy and have a rule.
In other words, we can be imperialistic, but not that imperialistic.
That's right. We wouldn't like it very much if they imposed their rules on us. I think we need to be at least a little bit balanced about it.
Thank you. My time has expired. Thank you, Mr. Chairman.
Thank you. We now go to the chairman of the Oversight Committee, Mr. Chaffetz.
Thank you. I do appreciate it. Former chairman, but...
You'll always be a chairman to me, Chairman.
All right, thank you. Mr. McGuinness, we cherish our relationship with the UK, and we thank you personally for what you do and for the relationship between the two countries. Mr. Downing, I think it's important for us to understand sort of the baseline, because if we're going to be trying to do things in other countries, I'm still concerned about what we do and don't do in this country. So first, help me understand about geolocation. What is the Department of Justice's position on geolocation? My concern is, and question for you, is does the Department of Justice consider that metadata, or is that content? How do you view geolocation?
Thank you for the question. Geolocation is a difficult and complex topic, as I'm sure we understand, and we've had discussions about this in the past as well. There are different kinds of geolocation that could be content or it could be non-content. It could be content if it's, say, the location data that's embedded inside of a picture file and is being passed as part of an attachment to an email. It could be non-content if it's simply information that the provider is gathering about its customers' use of cell towers. It doesn't actually have any contentful value in that situation. It's simply an observation of the company about which tower a particular phone is pinging off of when it's being used. So I think it's a
There
complex...
are times when geolocation is content, correct?
There can be times, yes.
Okay, so where do I go to figure out the difference in how you view, I mean, have you written this out? Is there some sort of definition the Department of Justice is taking on the nuances of what geolocation is and is not? Because I would argue that by and large, geolocation is content. It's the content of my life. If you can tell where I'm going with this phone all the time, you can pretty much tell the content of my life. And yet I worry about what you're gathering and not gathering, and I don't understand the definition.
So our view of the rules that apply when we're gathering geolocation information vary depending on what type of geolocation it is. Our position has been that if we are merely talking about what cell tower your phone is pinging off of, that is covered by the Stored Communications Act and would require a court order before we're able to obtain it. This is an issue actually that the Supreme Court has just recently decided to take a cert petition on, and so it will be very interesting to see how they resolve that question. There are other kinds of geolocation information, such as GPS, which is very specific and generally gathered prospectively. In those situations, I think, as you know, we use a warrant for that. So I think we use a nuanced approach. We look at the law that applies and try to do our best to comply with that law.
Well, I don't know that every department and agency, even within the Department of Justice, uses that same standard. And certainly when you start to look at Homeland Security and others, they don't necessarily follow those same standards. And so I guess what I'm looking for is in writing the definition of what that is. Let me ask you very quickly, on social media, is it the position of the Department of Justice, particularly in the hiring and the monitoring of existing security clearances, to look at social media? Is that fair game or not fair game?
You know, I'm afraid I don't know the answer to that question, but I'd be happy to take it back to get you an answer.
I think it is important. It's been struggled to try to get people, particularly in the realms of security clearances, even to get our own federal employees to be able to look at, you know, when they're assessing security clearances, to look at their social media and whatnot. And the last thing I want to ask you about is facial recognition. We know the Department of Justice, specifically the FBI, is building a database of facial recognition. What direction is this going? Where are the standards? What is happening or not happening in the building of the facial recognition database?
So I'm not intimately familiar with what the FBI is doing in that regard. My general impression is that they are developing a database similar as they would with fingerprints and other things of people who were of interest in an investigation, who were arrested, in order to be able to better
Okay, well, you obviously do, and with all due respect, you got a big plate but please do look at this, because that is not what they're doing. If they were looking at criminals, people who are incarcerated, people who committed crimes, that would be one thing. But what they're doing is, now more than 1 out of every 2 members of our society are in the database, or they have access to that database, I should say, because they're proactively going and gathering all the facial, or all the pictures that are on driver's licenses. A lot of states have MOUs with these states, and they were supposed to, the FBI was supposed to provide some notification. They didn't do that. And the big question is, I have a fundamental problem and challenge in taking innocent, suspicionless Americans and building a database, because we've shown we can't protect our databases. So I think we need to ferret that out as a committee. I won't be here much longer, but I do think that is something that the committee should take a much closer look at. With that, I yield back.
I thank the gentleman, and Mr. Chaffetz, in case we don't get another public opportunity on this committee, to thank you for your service for so many years and for your championing people's privacy rights, including geolocation. It's something that here on this side of the dais, center and left, we're all noting that somebody's going to have to pick up that chalice on your behalf.
No, thank you. I'm honored to serve, so thank you. Appreciate it.
Thank you. With that, we go to the gentlelady from San Jose, Ms. Lofgren.
Thank you, Mr. Chairman, and thanks to the 2 witnesses, especially our friend from Great Britain for his long travel to be here this morning, and it's a pleasure to hear your viewpoint. Obviously, our country and yours are close partners in the fight against crime as well as the fight against terrorism, so your words mean a lot to us, and we weigh them carefully, as well as, of course, our own Department of Justice. You come here at a time, however, when we are very much reviewing our own due process rules, and also some of the other issues that are pose challenges, not only to our government, but to our people. One of the things I wanted to raise, I understand that you're here for the best of motives, but we have a new general data protection regulation that the European Union passed in April of last year. And it's my understanding that that goes in, not of last year, it was 2016. It goes into effect in May of 2018. And here's my understanding of it, and correct me if you think I'm wrong. The GDPR requirement will be that data stored in the EU can only be transmitted to a non-EU country, for example, the United States, in response to a law enforcement request through a process that's ratified in a treaty. And so we've got, if that, we wouldn't use an MLAT, which is, we all agree, is inadequate and due to its complexity in the time. But I think we're going to have a situation next year where American companies are going to violate the law no matter what they do. And I'm concerned about that you're here for this matter, but this is going to hit the fan next spring, and I don't think it's fair to set up a situation that great American companies are going to be in violation of the law no matter what they do, and we just ignore that. So could either one of you comment on that?
Do you want to go first?
So I should say that that is not our understanding of the GDPR, the General Data Protection Regime. And the implementation of it is being worked through at the moment at European Union level and in individual member states. So we're working on that at the moment. And when we look at Article 48, which would appear to have that effect, we see that it has been nuanced, and it is our belief both that the provisions we have, and I think it's clause 53 of our Investigatory Powers Act, which allow for the reciprocity which I described, both that and the GDPR itself would allow for a transfer under the kind of agreement that we're working on here. That is our belief.
If I could just add, I concur with that. We've been having some discussions with international data privacy experts and with the European Commission, and as a result of those discussions, the department believes that the concerns that have been raised are inaccurate and overstated. We do not believe that the GDPR will pose significant conflicts for U.S. companies to comply with U.S. domestic.
Well, you know what I would really like from both of you following this hearing? I would like a statement that's definitive on that, that companies could take to the bank and that they could give to a court and as a shield, that they have relied on in good faith the representations. I mean, I personally think we ought to do a treaty that clarifies this, but I don't think there's much activity on that point, and there should be. I'm actually, I'll be honest, a little bit reluctant to take action until this other matter is addressed, and I don't think the administration, from what I've heard, is actively pursuing it, which I think is a mistake. I'll just lay that out, and I think I'm not the only member who has that concern. But if you could provide those definitive statements from the highest levels of your government, that would be very helpful, I think, to all of us, and certainly to American companies that feel really kind of stuck at this point. Mr. Chairman, I see my time has expired.
If the gentlelady would let me have her 14 seconds. Mr. Downing, I'm going to ask you the follow-up question to hers. If I were the Attorney General and I asked you to make the case based on the European Union order that you did have that authority, wouldn't you be able to make that case, or at least in good conscience you would plead it? Because the ordinary reading certainly would allow you to make that case.
Make the case, I'm sorry, I'm not following you.
Make the case that you could not transfer to the U.S. that data as a non-U.S. entity based on the simple reading that the gentlelady from San Jose alluded to.
Well, I can't say that I know the intimate details of the different articles of the GDPR, but in speaking with people, it seems fairly clear that there are a number of exceptions and loopholes and changes and whatnot that apply in this kind of situation.
That's always fertile ground for attorneys to make a case in a court.
Well, I certainly agree that having a clear and definitive statement from the European Union about this would be helpful, but I just want to be clear, we have to be careful about basing our legislation on concerns which may be completely empty.
Well, I join with the gentlelady in making the belief that until it is clear, crystal clear, it would be a fool's errand to create a situation in which companies would be damned if they do and damned if they don't.
If I could reclaim my
course.
14 seconds,
Yes,
Mr.
ma'am.
Chairman. I just think that we ought to have some further discussion on this point, and perhaps we could stimulate some useful activity on the part of the administration to get something positive done here. And I thank you for
I'll be
yielding
happy
back
to
the
join with the
14
lady in that, gentlelady in that. We now go to the gentleman from Ohio who's been patiently waiting, Mr. Jordan.
I thank you, Mr. Chairman. Mr. Downing, how long have you been at the Department of Justice?
Coming up on 18 years.
Okay, 18 years. We appreciate your service. A week ago, Mr. Comey, former FBI Director Mr. Comey, testified that then Attorney General Loretta Lynch told him to, when he discussed the Clinton investigation, to call it a matter, not an investigation. You recall that testimony from Mr. Comey?
I have heard news reports of that.
Okay.
Yes.
Okay, were you part of the discussion and decision at the Justice Department to instruct the FBI Director not to call an investigation an investigation?
No, sir. I'm a career employee of the Justice Department, and I was not involved in any of that level of.
Do you agree with that decision that was made and, frankly, implemented by the FBI Director?
I'm afraid, sir, I don't have an opinion one way or the other on that.
Do you know if that's ever happened before, where the Attorney General tells the FBI Director to portray something differently than what is actually happening, and i.e. not to call an investigation an investigation?
I'm afraid I have no information for you on that.
Were you part of any decision by the Justice Department to allow the perception to continue that President Trump was under investigation when, in fact, he wasn't and was told 3 times by the FBI Director that he wasn't?
I'm trying to make clear I am not involved in decisions of that level, and I have no information about it.
Do you think it's wise for the Justice Department to mislead the American people?
Of course, the Justice Department should do its best not to mislead anyone.
And you would agree that in both situations the American people were misled?
I have no basis to answer that question.
Well, think about it. In one situation, it was an investigation, and the FBI Director was instructed to call it something different, to call it a matter. In the other situation, the President of the United States was not under investigation, and yet that would not be confirmed, not be stated, and the perception was allowed to exist that, in fact, he was. Twice the American people were misled by the head of the Federal Bureau of Investigation. That's probably not a good thing, is it?
I have no opinion for you on that.
I mean, but, you know, you've served 18 years at the Justice Department. You went to Stanford Law School. You're a smart guy, a good lawyer. Is that normally how it operates at the Department of Justice? And well, let me ask this. Do you know of any other occasion where the Attorney General has instructed someone with an important job like running the FBI to mislead the American people?
I have no basis to believe that, no.
You don't think it's ever happened before? You don't know of any other time it's happened?
I don't have any opinion on that, no.
What about the leak? What about the idea that the head of the FBI decides to give information to a friend who's then going to pass it to the New York Times? Should that be something that actually takes place, even though at the time he was a former FBI director? Is that appropriate for someone who's held that position to engage in that kind of activity?
I'm afraid I also don't have an opinion on that.
But as someone who's worked at the Department of Justice for 18 years, Stanford law degree, you think that's the appropriate kind of conduct for someone who has served in the Justice Department, particularly at a high, not even as high a level as you, but someone who's been head of the FBI?
I think I could say that the FBI is a higher level than me. The FBI director is a higher level than me. No, I'm sorry, sir. I don't have an opinion about these kinds of questions. I understand the motivation and the need to try to get to answers on these questions, but I'm not the right person to be in a position to answer them for you, sir.
I appreciate you trying to respond, Mr. Downing. But what I also think the American people would appreciate is the highest officials at the Department of Justice should be straight with the American people. And that did not happen. No ifs, ands, buts about it. Did not happen. And they were misled at the direction of the Attorney General. Mr. Comey's testimony was real clear. He even questioned, he said, do we really want to do that? Don't we want to tell the American people the truth? And yet he carried out the order from the Attorney General to mislead the American people and say it was a matter, not an investigation. And of course, as I've said a couple times, he allowed the perception to continue that our current President of the United States was under investigation when in fact he was not. And with that, Mr. Chairman,
Would the gentleman yield?
I'd be happy to yield to the chairman.
Mr. Downing, I understand you can't always speak about things that aren't your main wheelhouse, if you will. Have you ever spoken to the press off the record, provided any information about an ongoing case to a press person?
I've certainly spoken to the press off the record, sir. Of course, we are very careful about what we disclose, and we try to do our best to stay within the lines, certainly at my level.
Okay, so I'll take that as a yes. Thank you. We now go to the gentlelady from Texas, Ms. Sheila Jackson-Lee.
Let me welcome both Mr. Downing and Mr. McGinnis and add my appreciation for coming across the pond and visit with us. Let me just take a moment to applaud my two colleagues from California and from Ohio. We have just seen, and I won't take long on this moment, but we've just seen an opening to begin an investigation into the President of the United States and the questions of the Russian collusion, obstruction of justice by the Judiciary Committee. I think we have been speaking about that for a very long period of time, and so I would ask Mr. Jordan to convey that to the leadership, chairman and ranking member of this committee, so that we can begin to open these investigations that the gentleman from California seems to want to answer about leaks and individuals speaking off the record. Mr. Downing, you answered appropriately. You're here for a particular topic, and thank you for your courtesies in responding to my colleague. But I think now that we have now put on record that Republicans are interested in getting to the truth of what has happened and restoring the integrity of our government, and certainly the number of witnesses are beyond even our imagination that could come before the Judiciary Committee to ensure that all of us have that chance to have questions asked and answered. I would hope that we could begin that post haste, and also I hope that we could secure from the Justice Department the many demands for documents that we have asked for, and I hope that we can do that. Let me indicate my interest in this topic and ask unanimous consent to put into the record to the chairman a letter from EPIC, Electronic Privacy Information Center, which is an organization that routinely files amicus briefs in federal courts regarding government cases, defends consumer privacy, organizes conferences for NGOs, but generally just understands the burdens of our providers and the whole question of releasing data. Even though this does not have anything to do particularly with the Patriots Act, I remember that discussion after 9/11, and the bill was rejected initially because we did not secure the privacy rights of Americans sufficiently. I maintain that that is my position continuously, even as we've moved into enormous levels of data seemingly everywhere. And so I ask unanimous consent to put this letter into the record.
Hearing no objection, so ordered.
Thank you. So I have two questions. One deals with the negotiations between the U.S. and U.K. The rules are different. I just came back from Malta meeting with the European Union parliamentarians, and we always discuss issues addressing cybersecurity, data, and we know that collectively, obviously, Great Britain is not in the middle of Brexit, but the point is that the rules were different, and that means that our companies here in the United States, in this agreement between the U.S. and U.K., may have some difficult obligations to meet with. So my first question is, why the secrecy, and when will the U.S.-UK surveillance agreement be made public, or aspects of it? And the second part is, what role of oversight do you believe the Congress of the United States, particularly that is in fact the people's representatives, should engage in with this agreement? Obviously, there are oversight and approvals that will come through, but ongoing responsibilities. So first, when is this agreement going to be made public?
So I don't have a particular deadline or timeline for you on when it would be made public. Frankly, we are at a bit of a hiatus in any discussions around it because we're waiting to see what action Congress may take on the legislation that would enable and authorize this kind of an agreement. We expect close collaboration, though, with Congress. That is our goal. We view this as an important piece of this. We've been working, of course, with the committee staff on both the Senate and the House and on the Foreign Relations Committee and the Judiciary Committee to try to make clear what we're doing. And we want to make sure that the congressional role is strong. Indeed, in passing the legislation would set all of the guidelines and the floor for what could be done under these agreements. And as I mentioned before, also an additional role at the end of the process. If we were to conclude with an agreement with the UK, there would be a waiting period at the end where Congress would have an opportunity to consider it and to weigh in if it chose to. So I think you have my commitment that we are very interested in working carefully with Congress and that we're not going to be out doing crazy things by ourselves. This is very much a collaborative effort.
Ms. McGinnis, though you come from across the pond, you understand the vital role of Congress in the protection of the privacy rights of the American people.
Yeah, I have the utmost respect for the US Constitution and its protection of US citizens and of the role of the Congress in that. I'd observe in this case, we have something which the companies have come to us and said, this is a potential solution to a problem we face, and on that basis we have gone forward. This isn't going to work if it's just done between governments. The tech companies which have brought us such wonders are critical partners in this, and they've been good partners in preparing it.
That is my very point. Mr. Chairman, I want to conclude. That's my very point about the burden that the tech companies will have to face. But, Mr. Chairman, I would think that it might be appropriate that we have, as we move forward, a classified briefing or opportunity to have the Justice Department back and begin to hear about just the levels of data that might be subject to the treaty as they're going forward. I'd like to ask more pointed questions, and probably it would be necessary to be in a classified setting. I'd like to put that on the record. With that, I yield back. Thank you for your answers. Thank you.
The gentlelady's observation and request is duly noted, and then she has yielded back the balance of her time. The chair will now recognize the gentleman from Pennsylvania, Mr. Marino.
Thank you, Chairman. Gentlemen, welcome. As a former district attorney and a United States attorney, I personally understand the complexities of modern-day investigations and criminal prosecutions. I understand the need for law enforcement to be able to get timely access to important information, particularly in the abduction of children. Over the past several years, I have introduced legislation addressing the issue of law enforcement being able to legally access information that is stored overseas. This year, I've been working with my colleague, Mr. Jeffries, to continue improving this legislation. The current legal framework, the Electronic Communications Privacy Act, or commonly known as ECPA, is insufficient for addressing the needs of the technology and society of the 21st century. ECPA is over 30 years old, and the original drafters of ECPA could not have envisioned the interconnected lives we live in today's digital world, and the Second Circuit said as much in its ruling in Microsoft. Now, Deputy Attorney General, could you please expand, and I don't mean to put you on the spot here because I just happened to glance at some of the opinions also. Could you expand on the DOJ's opposition to the Second Circuit's decision in Microsoft, the Second Circuit Appellate Court, and your legal basis of, I think was at least 2 and maybe 3 federal magistrates' courts' opinions that appear to me to be disagreeing with the Second Circuit's decision in Microsoft v. US?
Certainly, sir. There are actually 5 now lower court decisions in different circuits that disagree with that opinion. Our position is a fairly simple one. We believe that the execution of a warrant by a U.S. provider inside the U.S. is a domestic application of the Stored Communications Act. That is, the order is issued by a U.S. court, it's served on a U.S. provider, and a person inside the United States obtains that data, even if it's stored outside, and the moment of disclosure, which is where the privacy issue may be involved, is inside the United States. It's then reviewed by officers inside the United States. So our position is that this is not an extraterritorial under the rules, the legal doctrine of extraterritoriality, and therefore it is perfectly proper for the companies to do it, to disclose that information to us. And of course, as I've mentioned, it's so critical that we get this information in order to solve very real crimes, as you yourself pointed out.
Okay, thank you. Deputy McGinnis, welcome. I've had the opportunity to be a guest in England, in London, of Scotland Yard, and was out on the street with the agents, and it was quite exciting, very similar to our legal system here of prosecution. But it's good to see you here. We have about 196 countries in the world, and many of them will not cooperate with a democracy like yours and ours. Would you agree with me that it would be virtually impossible to have one universal treaty? And are bilaterals more realistic and less complex to achieve, however cumbersome because of the numbers that would be required? Do you understand my question?
I'd strongly agree with that.
What approach would you specifically, if you would mind expanding on it, because I know we've been working on one together, do you see a large portion of that bilateral agreement that would fit concerning other countries, and do you see many objections coming forward from those other countries based on what we have been working on? With Justice Department, I might add, Justice has been working with us on that.
So the work we've been doing, building on advice from the tech companies about what they felt would be workable and would provide a route to solve this problem of conflict of laws. The work we've been doing has both the effect of resolving the immediate issue with states that have shared standards, shall we say, but also a route to improve the behavior of other states. Now, clearly, that's a matter ultimately for the United States, how it wishes to use agreements to do that, but the United Kingdom is strongly supportive of it. And we're also most wary of data localization, which we see as a really pernicious effect. So we do see a way through this. It's hard to say, it's hard to exaggerate just how significant this data is for keeping citizens safe. And that provides a very powerful driver in any jurisdiction for a change in behavior and a compliance with the terms which will be laid out in something like this bilateral agreement. It is striking to me that in the exchanges that newly elected President Macron and newly elected Prime Minister May had in Paris only 2 nights ago, that in the very front of their mind was this question of what is to be done about securing data in order to secure citizens. So there's an enormous urgency to this, to resolve this issue and to get onto a proper footing. And I think I'd put that urgency before you as being one of the reasons to choose one vehicle over another for seeing through this business.
And I'm glad to see that we all agree that the tech industry has to be a part of this. They have a dog in this hunt just as well as we do. But I do want to add in conclusion, I see I've run over the time now, that many of the most serious cases that I prosecuted and where we reached convictions were based on using the 21st century technology that we have today. Thank you, and I yield back.
The gentleman returns his time. The chair would now recognize the gentleman from Georgia, Mr. Johnson.
Thank you, Mr. Chairman. Mr. Downing, Mr. McGinnis, welcome. Mr. McGinnis, welcome from across the pond, as has been stated. And we do value the historic relationship that we have maintained with Great Britain, and want that relationship to remain as strong as it has always been, and actually strengthen it. In this time of mutual threat, or threats that affect us mutually. as well as the rest of the world. But these two countries have led the world, and we need to continue to do that. I want to ask a question, Mr. Downing. In the event of a bilateral agreement between the UK and the US that would permit US companies to provide electronic data in response to UK orders targeting non-US persons located outside of the United States while affording the United States reciprocal rights regarding electronic data of companies storing data in the United Kingdom, what role do you foresee that Congress would have in approving, rejecting, or amending such an agreement?
As I mentioned before, I see a close collaboration between the Department and Congress as being an important part of this process. And in particular, Congress's role at the very beginning in passing the enabling legislation is a particularly strong role, since it sets the framework and the guidelines, the requirements of any sort of agreement that comes forward. There's also an important role under our proposal for Congress on the back end. That is that once an agreement has been worked out, it would be provided to Congress for notice. And of course, at that point, Congress could take steps if it chose to. But it's very much our expectation that we would be in close collaboration with Congress as these kinds of agreements begin to be worked out, assuming that we move beyond the first one with the United Kingdom.
So under the framework submitted by the department to Congress for this proposed bilateral agreement to be negotiated, do you see a role of Congress in terms of vetoing the agreement once it is reached? Possibly, would Congress have that authority under the terms of the legislation that you have submitted to us?
So I may not be the best expert on congressional vetoes, but it's my understanding that we can't write into the legislation an explicit veto, that's been found to be not constitutional. However, Congress would have the ability at the conclusion of such an agreement to pass a law, if it chose to, that could obviate that agreement. So Congress has an option, a decision that could be made. You can think of it maybe a little bit like the way the Rules Enabling Act works, where there's a period of time when Congress can choose to negate what has happened. But it's not an explicit veto written into the agreement, because I believe that's not a permissible use of a statute.
I see. All right. With that, Mr. Chairman, I will yield back. And thank you.
The gentleman from Georgia returns his time. The chair would now recognize a gentleman from Florida, Mr. Rutherford, for 5 minutes. And welcome to the committee, Mr. Rutherford.
Thank you, Mr. Chairman. I appreciate that. Mr. Downing, if I could go back just a moment to something you said earlier. You talked about UK law should control when the elements are in the UK and only the data is stored in the US. Now, and then you've talked about some standards that the UK has. Mr. McGinnis talked about necessity, proportionality, the double lock process. Could you, Mr. Downing, talk about other standards that you think a country should, if we're going to use a bilateral agreement, it's kind of a template for other agreements down the road. Could you talk about some of the other standards that you think should be met before the U.S. should consider entering into a bilateral agreement with other countries, particularly surrounding privacy rights?
Certainly, sir. The legislation that we've proposed would create a number of these kinds of restrictions that I think do set a very robust standard for privacy protections. They include things like orders have to be for specific persons. You can't do bulk collection under the agreement. It would require that any order be based on particularity and legality and credible evidence, for example, and has to be approved or supervised by a judge. There are a number of different types of rules like that, that we have tried to make sure that we are this would only apply to those kinds of countries that have a really robust system that respects privacy, civil liberties, and rule of law, and frankly, would not be available probably to every country in the world by any stretch. It's going to be a strong system that only countries that have similar, not identical, but similar kinds of procedures and processes in their legal systems as we do.
So would you envision that that through these negotiations we would, meet the standard of probable cause for a warrant by agreeing that, maybe necessity and proportionality do qualify as probable cause? Is that kind of how you see this going forward?
Well, I guess I wouldn't characterize it as that there's a requirement that other countries use the words probable cause or to have that exact concept. Frankly, I don't know of any other country in the world that uses that exact
No, but I mean, within the body of the bilateral agreement, we would have some term that would meet necessity and proportionality and probable cause, and we would all agree that meets the law of both parties in the bilateral agreement. Is that your intention?
Yeah, no, in the enabling legislation, it actually sets out those kinds of rules. And one of the requirements, for example, is that the orders be based on articulable and credible facts or evidence.
Mm-hmm.
So it's not exactly the wording of probable cause, nor is it exactly the wording of that, but it's the idea that you have to have a justification that is based on objective evidence.
I want to go back also to the issue that was brought up earlier, the difference between, would you make clear the difference between the request of data that requires a court order versus the type of data that requires a warrant and probable cause?
I'm sorry, under U.S. law?
Yes.
So under the Stored Communications Act, there's a range of different kinds of data that can be obtained. For the more sensitive information, like the content of communications, the Department of Justice generally uses a warrant when obtaining that kinds of information. On the other end of the spectrum, there might be just the name and address of the person who registered the account. That kind of information generally doesn't require a warrant. Instead, you could use a subpoena or perhaps a lesser court order to obtain it. So there's actually a range under U.S. law, but it's loosely based on the idea that more sensitive information gets better.
And law enforcement has been using that difference for a long time.
1986, yes.
Okay. But Mr. McGinnis, could you tell me, how does the UK treat, we've talked about it a little bit, but the incidentally collected communications that involve foreign persons, can you talk a little bit more about that? You haven't said really specifically, for example, if a UK subject communicates via email with a US person, what is done to safeguard the privacy concerns of the U.S. person's communications?
So under the proposals that you have here, you can see the stub, the beginning of what will be negotiated between us. Should Congress agree that there should be such an agreement? And what is clear there is that there will be protections for U.S. persons, whether that be a U.S. citizen or a person in the United States, physically in the United States, but a U.S. person, a U.S. citizen, wherever they may be, and any person within the United States, and that there shall not be collection of them, and that if we come across incidental collection, we will stop collection and delete the data. So that's the conception. I mean, that this is not aimed in any way at U.S. citizens, wherever they may be, and U.S. persons in the sense of anybody in the United States.
Mr. Downing, I assume the retention laws all still apply.
I'm sorry, the retention laws?
The gentleman's time has expired. The gentleman will be allowed to answer the question.
Thank you, Mr.
So yes, as Mr. McGinnis pointed out, the data would be minimized and not used. And I would also point out that we, as part of the agreement, would have the ability to audit the UK's practices, as they would have the ability to audit ours. And we expect that to be a robust process to make sure that both parties are complying with their obligations under the agreement.
Thank you. Thank you, Mr. Chairman.
The gentleman yields back. The chair would now recognize the gentleman from Florida, Mr. Deutsch, for 5 minutes.
And I thank the chairman. Mr. Chairman, I would start just by reflecting upon the comments of my friend from Ohio a little earlier, where He asked Mr. Downing some questions that weren't appropriately asked to be asked of you. They weren't appropriately to be asked in this particular hearing. But I hope that my friend from Ohio and my other friends on the other side of the aisle in this committee will seize upon the questioning that Mr. Jordan started this morning and will recognize that it is, in fact, the House Judiciary Committee that provides oversight of the Department of Justice. It is the House Judiciary Committee that provides oversight of the administration of justice in this country. It is the House Judiciary Committee that, in fact, historically has waded into important matters where obstruction of justice claims have arisen with respect to the President of the United States. And so I hope, while this is a terribly important issue, and I hope I get to my questions, I wanted to follow up on my friend from Ohio to simply suggest that it is appropriate for him to ask those questions. I know we have a lot of questions that we would like to ask as well, and in fact should be asking as members of the Judiciary Committee, of former Director Comey, of Attorney General Sessions, of the Deputy Attorney General, Deputy Attorney General Rosenstein, of the acting FBI Director, all of the sorts of questions that arise following just yesterday's headlines, last evening headlines that the special counsel is now looking at obstruction of justice claims. This committee, Mr. Chairman, has a responsibility to the American people to hold hearings. Yes, it's important for the investigation being conducted by the Intelligence Committee in the House and Senate to continue. Vitally important. Yes, it's important for the special counsel to pursue his investigation. But when it comes to the administration of justice in the United States, that falls squarely within the purview of the United States House Judiciary Committee. And my hope, Mr. Chairman, is that we will be able to come together to hold that hearing that the American people so desperately want us to hold. With that said, I thank you for your participation here today, to our witnesses. And while a lot has happened between today and last February, Congress still hasn't sorted out what is a massively complex issue, and I appreciate the chance that we have here to restart that work today. As I've said before, we have a long overdue and hugely important set of questions that we have to resolve as a country about how continuing evolving technology and privacy interact with the needs of law enforcement. And when we expand out these issues for our interconnected world, it only serves to highlight how many more questions we have than answers. That's what we're getting at today. And I think that really needs to change, and we have to do it fast. In my mind, there are two distinct problems here. First, how do we increase efficiency in cross-border data flow where the laws of the relevant countries are in agreement? That looks like either a patchwork of bilateral agreements to shortcut the MLAT process or a comprehensive reform of MLATs, or doing both. We've been talking about some of that this morning. Second is, what do we do where the laws are in direct conflict, or where where it's not clear which countries are the relevant ones in a given case? It's all too easy to envision a scenario where data stored in one country is requested by law enforcement in another regarding the information of a national of a third country. And while there's much more that I would like to say, let me start with that and ask our witnesses to respond what we would do in that situation.
I'm sorry, in the situation where there's data of a third party?
Data's in one country, the law enforcement in a second country, national of a third country.
So that's unfortunately quite common. In the case of Ireland, Microsoft stores data in Ireland, but much of the data there is not going to be about Irish citizens. It's going to be about many people, including Americans, who might have their data stored there. Our view is that we need to have robust authority to get that data. It's critical for solving terrorism cases, for solving child exploitation cases. Having quick and efficient means of getting it is particularly critical after the Microsoft decision, and we're seeking quick congressional action to try to deal with that problem.
And before I wrap up, I just asked the question, so the Department's position is that the government should be able to obtain data stored abroad by applying ECPA to companies based in the United States. What would the position be if another country made the argument? How would the Department react if the Chinese government required a Chinese company like Alibaba, for example, which maintains a data center in the United States, to produce account information that belongs to U.S. citizens?
So I think it's important to understand, sir, that it is in some sense the norm that countries claim the authority to gather data, even if it's stored outside of the country, if there is a person within the country who has access to it. So I've read a report, for example, that showed that countries as diverse as Canada and Mexico, Ireland and France, Australia and Norway, they all, like the United States, claim the right to obtain information if it's stored outside of the borders, as long as there's a person, like the company, is based inside the country. So it's not the case that the Chinese are going crazy here. This is actually kind of the norm, and how to deal with it is an important problem. Of course, ECPA, our rules, would prevent China, in many cases, from getting that, and it's that conflict which is, unfortunately, causing problems for our providers. That's why we've looked to situations like an agreement with, under the US-UK framework, which would ease that burden, and to make sure that we're doing it with appropriate countries, we have safeguards in place to make sure that that's the case.
That's an important discussion. Thank you, Mr. Chairman.
Thank you. The gentleman's time has expired. The chair will now recognize the gentleman from Arizona, Mr. Biggs, for 5 minutes.
Thank you, Mr. Chairman. Thank you, gentlemen. I was reading, Mr. Downing, your statement and listening to your comments today, and I want to take you to one particular paragraph that you talked to, that you wrote in here. It says, in particular, we recommend enacting and implementing legislation for this framework. And you talk about as long as there's an adequate protection of privacy and civil liberties, right? And you alluded to a term in kind of the framework that you've proposed, and I believe you used the term articulable suspicion. There's something
articulable and credible facts, I think.
Yeah, articulable and credible facts. Okay, so it led me back to this idea. That seems distinctive from the apparently American notion of probable cause, and it seems like a lesser standard. Tell me about that. And I think of the interesting term reasonable articulable suspicion, which is used in law enforcement, thinking of terms of probable cause, and then this kind of is a unique term that you've couched here. Tell me about that and how that protects rights and how that would adequately protect privacy and civil liberties.
So I think, as I mentioned before, we are seeking to figure out what an appropriate baseline level is, not to exactly mirror the way that U.S. law works. To start with the premise here that we are not targeting Americans. That is, that this is an event, for example, of a murder investigation in the UK. So having some deference to the other countries' laws, I think, is appropriate here, where it's really only the fortuity of where the data is located that causes us to have any interest at all in the case. If it weren't stored here, the UK law would straight apply. So I think it's important that we have appropriate safeguards, but they shouldn't be so stringent or frankly so requiring that they mimic ours that we end up with a situation where no other country can seem to qualify. I think we should find an appropriate level. I think we've created a really robust level of protections. I noticed one of the statements for the record of the second panel here says we shouldn't have any rules, that should just be any country is involved. I think we've come to the conclusion that it's valuable to have a robust level of standards, not identical to ours, but ones that I think would be appropriate and that we would have faith in as well.
The U.S.-UK bilateral agreement has been described as allowing wiretaps. I don't know if we've covered this today by the UK government. And traditionally, we've think of that as listening into telephone calls and whatnot. But here, we're talking about updating to, live, I suppose, emails, chats, and texting, et cetera. Is that fair understanding?
That's right. It would be, well, it would cover any range of communications, yes.
And so, Mr. McGinnis, I guess my question for you is, why is that important in this relationship, in this agreement? And yeah.
So thank you. That's a really helpful question, and this is a vital area. We're not only talking here about crimes that have occurred, investigating them and bringing people to justice. We're also talking about preventing crimes, including terrorism, child abuse, and other things. And in that context, live interception is a vital part of the toolkit. I have specific examples. An example would be from our National Crime Agency. They cite a gang of people who were selling child abuse, live feed child abuse online. And in order to identify both the people doing it and the children and the location where it was being done, you needed to be able to cover the actual event happening live, because it wasn't going to be stored data. So in that case, live intercept was a vital tool to get coverage there. The same can be said of terrorism incidents. If one is tracking people as they build towards an attack. And one of the things I would say to the committee very loudly, as an experience we have had in the United Kingdom in the last 3 months, is that speed is an issue. So that's the speed with which the internet is exploited by terrorists, and that's the speed with which people can move from the thought of an attack to an attack if they are using knives and a heavy vehicle that they hire for cash. And we've seen that in France, we've seen that in the United Kingdom. So there's a question about speed and what tool you need to deal with speed. I'd note that, like the United States, we see live intercept as a particularly intrusive power. And so I take you back to the point I made earlier about proportionality. So if it is possible to gain the investigative advantage, if it's necessary, to gain the investigatory advantage by a less intrusive means, we will do so. But live intercept sometimes is vital if we are to prevent people being killed or abused.
And Mr. Downing, back to you. We're using this effectively as a template for bilateral arrangements with other nations. And you've discussed it a little bit, but as Mr. McGinnis said, we are from the same root ball of civil liberties going forward. Can you tell me, what's it going to look like? What's Congress's role in your mind going forward as we proceed perhaps in other bilateral arrangements and negotiations?
So I perceive that we would seek to be in close coordination with Congress as we move forward. If it works out with the UK and we look to do it with other countries, we would do that. Congress, of course, has a critical role at the beginning of setting up the rules. What are the rules? And in the case of wiretaps, the rules that we are proposing Congress pass would include things like an exhaustion of alternatives, that you can't do it unless if a lesser thing would be possible, and to have a bunch of rules in there that would set an important floor for that. And then, as I mentioned, there's a waiting period at the end. If we were to conclude an agreement with the UK or any other country, then there'd be notification back to Congress and a delay before that agreement will go into effect. And Congress could act at that time if it chose to. So we see this as an important partnership in getting these kinds of frameworks in place. And I think that's sort of an appropriate way for us to proceed.
Thank you. My time's expired. Thank you, Mr. Chairman.
The gentleman's time has expired, and he's returned his time. The chair would now recognize the gentleman from Louisiana, Mr. Jeffries, for 5 minutes.
From New York, Mr. Chairman. I thank the distinguished witnesses for their presence here today, and let me thank Mr. McGinnis, first of all, for your thoughtful, heartfelt words at the beginning of your testimony in terms of the calamity that we experienced here in Congress yesterday, and obviously those thoughts are felt mutually in terms of what you are going through right now throughout Great Britain in terms of your citizens. In terms of Mr. Downey, I wanted to get your perspective on, one, the Second Circuit decision. Is the Department of Justice's position that Congress should take steps to reverse the holding in the Second Circuit?
That's correct. That's what we've proposed.
And can you explain why you believe that that is the proper course of action?
You mean as compared to having the Supreme Court settle the matter?
Sure.
Yes, we are, as I've mentioned, experiencing a very serious problem in gathering critical evidence in a whole range of our cases. And so we have been trying to seek whatever course is available to correct this problem. And our efforts to litigate it and to get the law changed through interpretation in the court continue. Unfortunately, it's a slow process. Even in the best of circumstances, the Supreme Court would probably take a whole nother year before it resolved it. Therefore, we are also seeking action in Congress. I don't see those as mutually exclusive. From our perspective, this is a critical problem that we need solved, and so having Congress act would be a perfectly proper solution to the problem.
ICPA was first passed in 1986, is that right?
ECPA was first passed, yes.
Correct. And since that, 31 years ago, since that moment, the United States has sort of emerged as a cradle of innovation throughout the world. Is that fair to say?
I think that's fair, yes.
And in the 21st century, we live in a global economy, correct?
We do.
And they're US-based tech companies that operate throughout the world, is that right?
They do, yes.
Would you say that's a good thing for the American people in our economy?
There have been many benefits for the United States as a result of that, yes.
So it's fair to say that we should make sure that these companies, in terms of our own national economic interests, can remain viable and competitive internationally in the current digital landscape that we operate, true?
Yes, that's true, and that's absolutely the case.
Now, placing United States companies in a position where they could be forced to violate the privacy laws of another country would also be problematic, correct?
Yes, I have sympathy for the situation that companies are in when they have faced competing legal demands. It's true, actually, of many different kinds of U.S. industry, and has been true, frankly, for many years outside of the context of telecommunications providers. There are, of course, rules to try to resolve those questions, but it is a fact of life for big multinational companies in any of our industries that they may have to deal with conflicting legal demands.
And I just want to drill down on this point in terms of competitive disadvantage and conflicting legal demands. If we place our own companies in an adverse position in terms of these competing legal demands and the possibility of conflicts of laws and violating privacy laws of other countries, or those countries being skeptical of our ability to match their privacy standards, doesn't that ultimately implicate United States economic interests?
Yes, I think that's true. Ultimately does have that impact. But of course, economic interests are not the only ones here. I don't mean to be combative with you, but of course we also have to take into account our public safety interests. And if we are doing things that benefit our industry but that have the impact, like the Microsoft decision, on the protection of children and the American public, I think that we have to make sure we're taking both of those things into account.
Correct. No, I just want to establish that there's a range of interests that are important in terms of what we as Congress should consider moving forward. National security interests, privacy interests abroad and foreign, as well as our own competitive economic interests. Is that correct?
Absolutely. I think looking for a solution that meets all of these needs would be the best path forward.
And in fact, I think Article 1, Section 8, Clause 3 of the Constitution states that it's Congress that shall have the power to regulate commerce with foreign countries. Is that right?
That's true, yes.
And so when you take all of this into account, isn't it fair to say that Congress should be intimately involved in whatever framework is developed from a bilateral standpoint or multilateral standpoint in terms of dealing with data sharing?
Absolutely. As I mentioned before, we see close coordination with Congress is important, and of course, setting up the whole framework is a role that we're asking Congress to take on in terms of the US-UK, to be able to set up the rules that we would have to follow in passing any kinds of future agreements with other countries.
My time has expired. I want to thank Congressman Marino for his leadership in this area, and also point out that, close coordination is a vague phrase. I think we're going to have to drill down on specifics as it relates to the power to accept, reject, amend, and what form that takes, either in the treaty context or in, the administrative review context, has been used in other instances. Is going to be important for us to move forward. Would you agree?
Yeah, no, it certainly is a
Gentleman's time has
question.
expired. The gentleman be allowed to answer the question.
Yeah. Simply say, yes, it's an important question that we're going to have to resolve.
Thank you. I yield back.
Thank you. The gentleman from New York has returned his time. With the apologies of the chairman, now I recognize the gentleman from Texas, Mr. Ratcliffe, for his 5 minutes.
Thank you, Mr. Chairman. I appreciate the witnesses being here today. I've been bouncing between meetings and other hearings, and so I apologize in advance if I'm going to ask you something that's been that may seem repetitive to you. Mr. Downing, if I understand correctly, certain proposals for addressing the issues that we're examining today would be to focus less on the location of the data itself and more on the citizenship and physical location of the individual about whom the information is being sought. Does it concern you from a law enforcement perspective about a scenario where a U.S. company doesn't know the citizenship or physical location of the individual and so declines to turn over the evidence? Or I guess related to that, feels that the government hasn't sufficiently established the citizenship and still declines?
That's absolutely a concern of ours. If we have a rule which is based solely on the citizenship of the person, and it doesn't take into account the very common situation where we don't know that person's citizenship, and that blocks us from getting evidence, that's a very serious problem. We often are in a situation where we have, let's say, a hacker or a child sexual exploiter who is hidden from us by the anonymity that's provided by the internet. It can't be that we don't get to access that information simply because we don't know who the person is yet.
Okay. I caught as I was walking in, someone was asking about wiretaps. As a former prosecutor, my perspective on wiretaps is they're traditionally thought of as listening into phone calls in real time. The request from the UK here with respect to the U.S.-UK bilateral agreement would not be to do that, correct?
I'm sorry, did you? The rules that we are proposing would be that if there is a targeting of an investigation which is not a U.S. person, if it's a UK person, for example, and they need to get a wiretap for that person, but the only place that the wiretap could be effectuated is in the United States, that it would be part of the agreement that they could use their own wiretap law, their own wiretap order, with their own restrictions, and then the U.S. company would comply with that foreign legal process.
Okay, and so would it also apply in the context of text messaging and other features like that?
Yes, absolutely. It would be for all kinds of communications, not just verbal ones.
Okay. So then let me ask you, Mr. McGinnis, and I appreciate you traveling all the way here, and I represent East Texas, and I've enjoyed listening to your Far East Texas accent this morning. But one of the topics that's the subject of debate and ultimately reauthorization here in this country will be tools like 702 of our FISA Amendment Act, that a tool that can result in the incidental collection on U.S. persons. So how does the UK treat incidentally collected communications that involve foreign persons under this?
Let me say, first of all, my family in East Texas, so I hope you're looking after them well, my aunt and uncle and cousins. To be clear, and I think we've said it, but it's worth saying again, the proposed UK-US framework that we're talking about is not about US citizens and not about persons in the United States, so categorically not. When we talk about foreign persons and how they are protected in this, it is US persons who are protected. Other foreign citizens are not. That is because the conspiracies that we look at for almost everything that we look at under serious crime, unless there is a single actor, involve people of multiple nationalities. And that's true if we're looking at, I know, Albanian crime groups trafficking people into the UK. That's true if we're looking at recent conspirators and attackers in the United States, in the United Kingdom, targeting who've carried out attacks. There are multiple nationalities and multiple connections externally. And we covered this a little bit earlier, but it's worth repeating, within this agreement and within the language that has been sent by the administration of the Congress, there is a very clear protection for the rights of US citizens and US persons, and an expectation that should we inadvertently collect the communications of a US person, that as soon as that is evident, we will desist and we will delete the data, we will minimize the data and so that protections are in place. That is obviously something, the exact detail of how we do that is to be discussed if you agree there should be an agreement, but I am confident we can set a very high standard.
Okay, that would apply, and my time's expired, but so that would apply if, for instance, a UK subject communicates via email with a US person. Those are you're talking about applying those privacy safeguards to the US person.
Indeed, if I write to my cousins.
Yeah, okay, very good. I appreciate that. Thank you. I yield back.
Gentleman yields back his time. The chair now recognizes the gentleman from Rhode Island, Mr. Cicilline.
Thank you, Mr. Chairman, and thank you to our witnesses, Mr. McGinnis in particular. Welcome. We appreciate your long travel, and thank you for your thoughtful words at the beginning of your testimony, and I hope you feel the same prayers and thoughts of the entire, all of the American people with respect to the citizens of the UK, and particularly the families of the loved ones who were killed or injured in those attacks in your own country. I think there's broad consensus in our committee that we need to urgently respond to the issues that both of the witnesses have raised. And I think our committee took up the Email Privacy Act in the hope of developing and implementing a uniform domestic standard for law enforcement based on probable cause, a standard we're familiar with here in the United States, but that we also need a uniform standard that provides clear guidance to all parties for overseas applications of electronic information. And I think as the gentlelady from California mentioned, it's a particular concern to American companies. We don't want to put them in a position where, despite their best efforts to comply with prevailing law, that they're in a position of, by any action, either complying with one law and inadvertently or unintentionally violating another, and it puts them in an impossible position. So I think it really underscores the urgency of our work. And so I guess my first question is kind of what your sense is, that is both of you, with respect to the current MLAT process. There's been a lot of talk about reform. Is it mostly that it has to be, that we have to figure out ways to accelerate the decision-making and application process? Is it mostly strike the right balance, or are there, beyond sort of the speed and efficiency of it, are there other reforms that you think are critical? And particularly your thoughts on the legislation that was introduced in the last Congress by Ms. Del Bene and Mr. Marino. Did that strike the right balance and address all or most of your concerns?
So I think I want to be clear that the MLAT process is an important tool, but I think it's also clear that as we have entered a global and internet-connected world, that it is not a sufficient tool that we can use in all the kinds of situations that we need. That's why we are looking at faster processes such as the US-UK agreement. That being said, I think we aren't going to ever reach a point where we have bilateral agreements with every country in the world, and even if we did, there are still going to be the need for mutual legal assistance treaty processes, for example, when the UK needs information about a criminal in the United States. However, the MLAT process will be benefited, interestingly, by bilateral agreements, because it will take some of the pressure off of it. Some of the cases could be handled in that way. You have to think about the MLAT process in two directions. One is our outbound requests, how quickly other countries are complying with that. Unfortunately, it's often very slow and cumbersome, and of course, we don't have MLATs with some countries. As far as the inbound requests, we at the Department of Justice are taking a lot of steps to try to do a better job of it. Unfortunately, the requests, especially for electronic evidence, have just risen massively over the last decade, and resources have not necessarily kept pace with that. We've done a number of reforms, though. We've created a whole cyber team to focus on these kinds of requests in particular. We've improved efficiency by focusing our efforts by going to the courts here in the District of Columbia rather than spreading these out all over the country. And we've really made some substantial gains. I had a couple of figures prepared. In the 2013 to 2016 timeframe, we saw our increase in our requests go up by 175%, but the number of ones that we were able to resolve went up by 532%. So we're cutting into the backlog. We're doing a better job of it. However, there are still a lot of hurdles. In particular, this was partly accomplished by a one-time transfer of funding from one pot to another. And without a sustainable amount of resources to put into this problem, we actually hired a number of attorneys. We need to be able to support them if we're going to continue to make progress on this. So I think there are opportunities for improvement. We will continue to work hard on that. And hopefully, we will also be able to see improvement when we make our requests going out, which is consistently also an issue that we are going to have to grapple with as well.
Thank you. Mr. McGinnis?
So I'd strongly endorse what Mr. Downing has said about the importance of MLATs, both actually bilaterally between the UK and the US, but also as a mechanism that will allow us to deal with countries that can't reach the high standards that are being set by this proposal here. MLATs are too slow. Well, we need to do work on that. We need to relieve the pressure on them, absolutely. They also are backward-looking, and I think we'd all agree that in some of the egregious crimes that we're looking at, these terrorist attacks and conspiracies that we have, child sexual exploitation, trafficking of human beings, that actually we want to get into stopping it and preventing it, and the MLAT won't really allow you to do that except in prosecuting some of the people doing it. So this agreement allows us to do more of that preventative work to our mutual benefit.
Thank you. I see my time is expired. Thank you both.
Thank you.
Gentleman from Rhode Island has returned his time. The chair will now recognize himself for 5 minutes. And I'd first turn to Mr. Downing and thank you for your testimony. And I wanted to understand how Section 2703 warrant is actually issued, the functionality of that. Could you explain that to the panel?
Absolutely. 2703 warrants are actually executed much more like a subpoena. The officer would swear out the warrant before the court, supply probable cause, do all the steps, and have the judge sign it. And then that is simply provided to the provider. Under 2703A, it says that the warrant may compel the production. That is, it's a compulsion order, not a situation where the officer goes to Google's headquarters with a gun and says, stand away from the keyboards, I'm here to seize the evidence.
How does it actually arrive then? You know, how is it actually presented to, say, Microsoft in Ireland? How does it get there?
So we would normally not present it to Microsoft in Ireland. We'd present it to the domestic service provider. It varies between providers. In the old days, we would fax them. Now there are electronic means of transferring the information.
Okay, so I get that. Then you swear out a warrant, the judge approves it, and then the document, perhaps a PDF document, is emailed then to the company that is in control of the information you're seeking.
That's correct.
And if that company is domiciled in Ireland rather than the United States, is there a legal difference?
Domiciled? No. I mean, if the company is in the United States, doing business in the United States, employees in the United States, we would regard that as being under the jurisdiction of the court.
Okay, so any company domiciled anywhere that has a U.S. presence then is subject to a 2703 warrant?
Any company that would be inside the jurisdiction of the court, yes.
Okay, and if that company then holds that information in Ireland, is a topic we're discussing here, and you don't review that data until it's back inside the domestic boundaries of the United States.
That's true, yes.
And
it would be disclosed
that's how
to
you
us here.
qualify that a warrant then is valid and can be applied under these circumstances we're discussing?
Well, it would have to be that the company not only has a presence here, but that there is a person inside the United States who has possession or control over the information. So in the case of Microsoft, for example, the employees
or
here
access to that information that might be held in a foreign country.
Or access to, I'm sorry?
Well, as I understand this case with Microsoft, the data was in Ireland.
That's true.
And the warrant was served, we think, to the Microsoft officials here in the United States.
That's correct.
Who then were compelled by the court to access that information and deliver it to justice.
That's correct. They had possession or control. Those are the sort of legal words of this.
Let's just say you had a justice official in Ireland that was that could walk into the headquarters in Ireland of Microsoft, and that warrant was served electronically and emailed over there to Ireland. Could they, under this warrant, could they hand them the data off of their hard drive, say in a thumb drive condition?
I'm sorry, I lost you on that, the hypothetical.
Well, I'm just intrigued by this legal technicality of if the data is in a foreign country and there's a U.S. presence for that company, the warrant can be served in America, but you can't look at the data till it gets back into America. That seems to me a very finely split legal hair. And I'm trying to understand that rationale. We've seen some of these finely split legal hairs rationale in the past before this committee, and they don't always hold up.
I guess I don't see it as a legal hair. Over the last many decades, we've had situations where we serve a subpoena on a company and the paper documents might be located overseas. Perhaps they're bank records. And we've required the company to comply with that subpoena. And we have a whole doctrine to deal with the potential of conflicts of law. If the company comes forward and says, I can't do it because there's a real conflict, then the courts would balance that kind of conflict. I would expect that kind of analysis would be what would happen in this situation.
And my time is clicking down, but I was caught by perfectly proper, and I'll dig into that perhaps a little later. But I wanted to take this opportunity to thank Mr. Patty McGinnis for his presence here, and I want the committee to know that you rolled out significant hospitality to myself and Chairman Goodlatte and several others almost a year ago, around June 25th or so last year, shortly after the Brexit vote. We had a deep and engaging discussion, and were very well informed by yourself and a number of other persons that were there in that briefing table. And the intent that flowed from that discussion seems to also flow from your testimony here today. And I want to thank you formally for your efforts on this. And my sense of what we have negotiated so far is in keeping with those things that we saw and discussed in London almost a year ago. And any final words you'd like to say, Mr. McGinnis, I'd like to hear them.
Thank you very much. Can I say, first of all, I am most grateful for the engagement of this committee in this business. This is vital interest to the United Kingdom. This will enable us to keep ourselves and our American allies safer, and so I'm most grateful for it. I'm also really grateful, and we have been heartened and our resolve strengthened by the support, the practical support we have received from the United States, but also the moral support, and I heard some of it here today, in the face of what has happened to us over recent months. And I suppose my last message, apart from of being grateful, is simply to say that we are resilient and are confident of our ability to see through this slightly difficult period and get to a better place, not least with your help.
We have fought together through much more difficult endeavors in the past. We'll demonstrate that to the world, Mr. McGinnis. Thank you very much. And I would see my time has expired now. I'd recognize a gentleman from Maryland, Mr. Raskin, for 5 minutes.
Mr. Chairman, thank you very much. And Mr. Downing, Mr. McGinnis said, welcome. Thank you for your excellent testimony. Mr. McGinnis, let me just echo my colleagues in saying we thank you for your words of solidarity and encouragement, and we return them to you and the people of the United Kingdom as you deal with the violence and terror that have beset the people of your country. I'm persuaded very much by the testimony that the laws governing law enforcement access to data across borders are in critical need of revision and modernization at this point. And because of the Second Circuit decision in Microsoft Ireland, the U.S. law enforcement is blocked from accessing data in legitimate investigations based simply on the fortuity of where the data happens to be held. And the mirror image problem applies to foreign countries in trying to access data that you need in order to solve and prevent crime. So the suggestion, as I understand it, is for a bilateral agreement between the U.S. and the U.K., and then perhaps a series of bilateral agreements with other countries. I want to make sure that both of you agree that such agreements should only be undertaken where both sides respect basic rule of law principles and basic human rights principles. Am I correct in saying that?
Absolutely, yes.
And Mr. McGinnis, you agree? Presumably.
Strongly so.
In other words, we're very happy to guarantee the mutual transmission of law enforcement data when we know it's not going to be abused, when we know that the government that obtains it will respect the rule of law, the ability of people to defend themselves, have notice and opportunity to be heard, and so on, and where basic human rights norms are, in fact, being observed. Does it follow, then, that the countries with which we engage in such mutual bilateral agreements themselves should also not turn over any law enforcement data to authoritarian regimes or regimes that fall outside of a rule of law or human rights framework? Does that follow?
I think I wouldn't be quite so categorical about that. It's also possible that authoritarian regimes have their own perfectly legitimate crime and security problems, and there may be situations where evidence lawfully gathered could be used to prevent a serious terrorist attack in another country. Nevertheless, your basic premise is right, that there should be appropriate restrictions on the sharing of information, and that it shouldn't be used as a free ride or a way of getting any benefit that wouldn't normally be there.
So if I may, so far clearly we've been having in principle discussions of what an agreement might be like rather than what an agreement will be, because we don't have your agreement, there should be an agreement. But our understanding has been, our expectation is that there won't be onward passage of data that is provided through this reciprocal agreement, but the effect of the data, so let us say we're investigating an Albanian crime group, we get coverage of it, and we learn of a harm that is occurring in a third country that doesn't have appropriate human rights standards or privacy respect or whatever it is. We would still want to tell them of the harm and enable them to deal with it, and we'd go and do that. We just simply wouldn't give them the data. So we'd give them the result of the investigation, and I think that provides us with some protection.
And then that's for the purposes of crime prevention.
Yeah, for the purposes of crime prevention, for instance.
What's the scope of the agreement in terms of which crimes are incorporated within it? I think I saw someplace that serious crimes, but is there any definition of that? Is that what we call felonies in the United States?
So the definition we've been working on in the United Kingdom is a crime which gets a sentence of mandatory sentence of 3 years or more. So that provides us with a baseline, and then we go above that, and that covers the range of crimes that we've been using in our testimony today.
Gotcha. And to what extent do we need a multilateral treaty to deal with this, and could such a multilateral treaty actually advance rule of law and due process concerns in countries where it's in danger?
So I think the idea that other countries may be willing to raise their standards in order to meet their obligations under this, in order to get access to this type of agreement, is very much one thing that we have given some thought to, and I think an advantage of the system that we have. We're open to all sorts of ways of thinking about this and doing it efficiently. So having a multilateral agreement could be a way forward, so long as all the countries that were in that group met the basic rules that we're setting out, that Congress would set out if they were to pass the proposal as we've suggested it. So it would have to be that they all meet that robust standard, but having a more efficient way of doing it on a faster basis, that's something we'd certainly be open to.
Okay, I've gone over, Mr. Chairman. I yield back. Thank you.
The gentleman from Georgia, Mr. Collins, recognized for 5 minutes.
Thank you, Mr. Chairman. I think one of the things we've seen here, Mr. McGinnis, thank you for being a part of this, and I think it is an interesting, I want to start with you and then I'm going to come to Mr. Downing. In the treaty perspective, and I know there's been some discussion that we just handle this sort of in a treaty mode, that we do it bilaterally, which I think with one of our greatest friends, the UK, would be not a problem. But the reality here is this is a subject that spans far more borders than just this. How would you see that? And I think following up a little bit on my friend from Maryland's question is how do we see this with other players, China, others that, where these markets are, or even in the EU working that? How is really bilateral? It's a good step, but it's not really addressing completely this issue, would you think?
So if I may, I think I have a couple of thoughts for you. The first thought I have is that this way forward is one we have worked up with the close support of the major US tech companies who see this as a way out of the bind that they are in. And they see it as a way we can build incrementally into a better space. First thought. Second thought, when I go and talk to European colleagues, as I do regularly, they are people in a closed room with no exit, where they are suffering from crime, or in the case particularly of Northwestern Europe, they're facing terrorism of a kind that they find it very hard to deal with, and they haven't got the data that they need. And they're thinking of solutions within their national boundaries, data localization and the rest. And this agreement is a way out of that position, So it may be that you do it individually with them. It may be eventually you're able to do it more broadly. But what we need, as I think the Justice Department has said, is we show there's a way of doing this. If we show there's a way of doing it, we'll see it through. Lastly, in terms of China, I think as we had a question earlier about standards in North Korea and Cuba and various other states, it'll be a wonderful thing if we can get them to raise their respect for freedom of expression and privacy and the rights of the citizen. There are other mechanisms for providing data to them, and we talked about MLAT here. And I think we're just going to have a multiplicity of ways of dealing with the more difficult jurisdictions. But actually, we have that anyway in our interactions with them.
Well, look, I'm very sympathetic, especially our tech companies, especially here in the U.S., are outstanding. And they have, they model and they go around the world. I think those are some issues. I think not only raising security, privacy, but also protection and content. There's a lot of other issues here that we could get into with this situation. Mr. Downing, but though I do believe that there is an issue here, then it's been addressed here, and we're looking at it from a legislative standpoint. And based on the written testimony, it is safe to assume that the government, your belief is the government should be able to obtain this information regardless, correct? In the United States, regardless of the data's location.
That's correct. Okay. That's our proposal.
Well, and just hypothetically here, if so, how would we, I guess, as a country react if we adopted this position, for example, if the Chinese government required a Chinese company like Alibaba, which maintains data centers in the U.S., to produce information that belongs to a U.S. citizen? So wouldn't that jeopardize individuals' interest here and companies here in the U.S.?
It is already the case that the Chinese government claims that right, as do, frankly, as I mentioned, many countries around the world: Canada, Mexico, Ireland, Australia.
Well, we're sort of the buffer at this point to say, hang on a second, that's why this Congress legislatively should be looking at this, because, that, again, I think that's the question I'm saying, are we tactically going down a road that is not, at this point, lining up with the privacy needs and privacy interests with our companies and with our citizenry in regard to regimes that we would never agree to this on any circumstance?
So with respect to, say, a country that we would not be willing to enter into a bilateral agreement, for them, the restrictions on disclosure under ECPA would not be lifted, and therefore the Chinese court orders would likely not be complied with by the U.S. companies. So we are interested in reducing those conflicts of law for our companies, but doing it in a selective and positive way with countries that we can agree have a respect and a robust protection for civil liberties and the rights of their people.
Well, and I think that's as we get to do here in hearings, and even with the second panel and others, which will be in and out of a lot, that's the ideal. And I think, but we also have to reel in the realities of data and companies in the U.S. and others, and where they store their data and how they move their data and how some of these are applicable interest. And I think that has to be given some deference to these tech companies and the growth. We're still, even in the expansion that we've seen in the last little bit, are still at that area of growth that people more and more depend on this privacy, more and more expect this privacy. And I think it has been said even 10 years ago, this is the next big debate that we have to have. And I think it is something that I'm very concerned about, especially dealing with our companies who are providing this. And it's a balance. And so for me, it's just really a concern here that the DOJ look at it also from our perspective as well. And when we legislatively fix this, it's not just we're not going to go here, we believe this, but there is a balance that we need to strike. And that's the thing I believe so, and I think our tech companies deserve that, but more importantly, the American people deserve it, and from a citizenry of the world with our friends across Europe and other places. So with that, Mr. Chairman, I yield back.
Chair, thanks, gentlemen. Recognize the gentleman from Washington, Ms. Jayapal, for 5 minutes.
Thank you very much, Mr. Chairman, and I just want to again extend my thanks to both of you, and specifically to Mr. McGinnis for making the journey at a very difficult time. You know that the United States stands in firm alliance and solidarity with the United Kingdom. I absolutely agree that we need a comprehensive framework that takes into account our very global, interconnected economy, and at the same time balances our many needs. And of course, we're very proud in Washington State of our extremely innovative tech sector. We want to make sure that the economic benefits of our digital economy continue to come to the United States and benefit the United States. We also want to make sure that we are protecting the global, national, and domestic security, and protecting our civil liberties and privacy rights of U.S. citizens. And I agree with our ranking member when he said at the very beginning that we do need to make sure that we get our details right. Mr. Downing, I wanted to just follow up on Mr. Raskin's question about what constitutes serious crimes, because obviously public discussion is centered around investigations into serious crimes. I know Mr. McGinnis defined it as anything that gives you 3 years or more, but can you give me a little bit more detail in terms of how we would assess what is truly a serious crimes, and would these agreements also apply to less specific national security threats? And with regard to the serious crimes, because of the way our justice system works, we have a lot of mandatory minimums. We have other things that put certain crimes into a framework that may not comport with the United Kingdom. Can you just give a little bit of insight into that?
So we were choosing the framing of serious crime in order to provide at least a little bit of flexibility, as different countries, as you correctly point out, have slightly different approaches to sentencing in their different countries, and what might constitute a particularly severe sentence in the UK may not be quite regarded in the same way. I would see, for our law, it would be, felony crimes would be probably a rough and ready way of looking at it. But the reason we didn't try to specify it with even greater specificity in the proposed framework is that there may be a need for some flexibility. With respect to national security threats, I want to be clear, this is not an intelligence gathering tool. The agreement is aimed at the investigation and prevention of crime. Of course, there are some national security threats, such as terrorist threats, that also are crimes and so would be covered here. But it's not intended as a sort of counterintelligence or other national security work. It's a provision oriented towards solving and preventing crime.
That's helpful, thank you. And in the proposed legislation from the department, you talk about orders issued by a foreign government must be subject to review or oversight. Can you clarify exactly what you mean by oversight? What would Congress's role be in that? How do you foresee Congress having that very active role in oversight that I believe we should have?
So I think the provision that you're referring to talks about the oversight of legal process that's issued within one of the two parties. That is, when the British police officer is investigating an organized crime group, there needs to be oversight of the application for that court order. A slightly different question, I think, is what Congress's role in overseeing this entire process of developing a framework and an agreement. And as I've said, I think it's our expectation is that there will be close collaboration with Congress. We've certainly worked hard over the last year to try to be involved with committee staff, on both sides of the House and the Senate. We also see a strong congressional role in setting up this whole framework. It's very much a congressional choice to be able to figure out what the rules ought to be for these agreements going forward. And then there would be notice to Congress before any agreement goes into effect to make sure that Congress has a role at that stage as well.
And so you would be willing to subject these agreements to a vote by Congress?
So the proposal doesn't formally create a requirement that there be a vote by Congress. This is more like, I suppose,
would you be willing to agree to that, though?
I'm not sure what you mean, a vote by Congress. I think Congress is, of course, always able to pass a law that would block this kind of thing. So that it doesn't need to be said, I suppose, if you like, that Congress has that authority to do so.
Thank you. Mr. McGinnis, one of the chief concerns underlying this discussion has been the move towards data localization. And I know my time has expired, but if you could just quickly say, economically and politically, what are some of the harms of data localization laws?
So the United Kingdom, Her Majesty's government is opposed to data localization. And we're opposed to it because we think it undoes the good that has been done economically and in terms of our ability, frankly, to live our lives that we get from network systems that are agnostic about where data is and where it goes. So we're opposed to it. We see data localization as, and the companies are better to speak to this, and I think you have colleagues from Google coming afterwards, but we see it as, frankly, slowing down the functioning of the internet in itself, but also perhaps technically, but also, frankly, potentially limiting the value of commerce through the internet. And also, frankly, it's going to lead to many more difficulties about ownership of data and the working system. So we're opposed to it. It's a matter of policy.
Well, I want to thank both of you for your participation and forbearance. We've been going for over 2 hours, and we thank you both for a very interesting testimony and very important issue. So thank you, Mr. McGinnis, for coming across the pond, as they say, to join us today. And Mr. Downing didn't have to travel quite as far, but it's important that the two of you be working together on finding ways to solve this problem, and we will definitely be playing a role up front and as we move forward. So thank you both.
Thank you very much. We look forward to working with you.
Excuse you and move to our second panel. And for those of you who may be wondering, we're going to go right into the second panel. So if Mr. Salgado and Mr. Littlehale and Mr. Calabrese and Mr. Woods would come forward, we'll get started right away. While you're still standing, why not remain standing so I can swear you in, and then I'll introduce all of you. So if you'd raise your right hand, do you and each of you solemnly swear that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? I do. Let the record reflect that all of the witnesses responded in the affirmative, and I'll begin by introducing Mr. Salgado. Mr. Richard Salgado is the Director of Law Enforcement and Information Security for Google. Previously, Mr. Salgado was with Yahoo, focusing on international security and compliance work. Mr. Salgado has also served as Senior Counsel in the Computer Crime and Intellectual Property section of the United States Department of Justice. At the Department of Justice, Mr. Salgado specialized in investigating and prosecuting computer network cases that dealt with technology-driven privacy crimes. He has served as a legal lecturer at Stanford Law School, adjunct law professor at Georgetown University Law Center and George Mason Law School, and as a faculty member of the National Judicial College. He is a graduate of the University of New Mexico and Yale Law School. Mr. Richard Littlehale is the special agent in charge of the Technical Services Unit at the Tennessee Bureau of Investigation. Mr. Littlehale coordinates and supervises a wide range of advanced technologies in support of law enforcement operations. Mr. Littlehale, along with TBI special agents, specialize in developing evidence from communications records in a wide range of cases, including homicides, internet crimes against children, and computer intrusions. Mr. Littlehale has also served as a legal advisor to the Tennessee Bureau's Drug Investigation Division. In this role, he was responsible for providing field and office legal support for TBI criminal investigators and their supervisors. Mr. Littlehale is a graduate of Bowdoin College and Vanderbilt Law School. Mr. Chris Calabrese is the Vice President of Policy at the Center for Democracy and Technology. Mr. Calabrese has long been an advocate for privacy protections, having testified before Congress and appeared in many news media outlets discussing technology and privacy issues. Previously, Mr. Calabrese served as legislative counsel at the American Civil Liberties Union, Washington Legislative Office. While at the ACLU, Mr. Calabrese led the office's advocacy efforts related to privacy by developing proactive strategies on pending federal legislation concerning privacy and new technology. Prior to joining the ACLU, he served as legal counsel to the Massachusetts Senate Majority Leader. As legal counsel, Mr. Calabrese helped on legislation pertaining to privacy and anti-discrimination laws. He is a graduate of Harvard University and Georgetown University Law Center. Professor Andrew Kane Woods is an assistant professor of law at the University of Kentucky College of Law. His teaching and scholarship include cybersecurity and the regulation of technology, contract law, international law, and empirical legal studies. Previously, Professor Woods was a postdoctoral fellow at Stanford University at the Center for International Security and Cooperation. Prior to that, he was a fellow at Harvard Law School. Professor Woods is a graduate of Brown University, Harvard Law School, and was a Gates Scholar at the University of Cambridge, where he received his PhD in politics. I want to welcome all of you. Your written statement will be entered into the record in its entirety, and we ask that you summarize your testimony in 5 minutes. To help you stay within that time, there's a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, that's it. Your time is up, and we will start with Mr. Salgado. We'll start with Mr. Salgado. Welcome.
Chairman Goodlatte and members of the committee, thank you for the opportunity to appear before you this afternoon to discuss the issue of cross-border law enforcement requests for user data. Today, I want to discuss two distinct but related challenges that confront law enforcement agencies and service providers alike. These challenges arise from the fact that ECPA, a statute that has been vital for decades, has become antiquated in some key respects. This has left courts to interpret the statute in the context of facts that Congress could not have anticipated in 1986 when ECPA was passed. It also leaves law enforcement agencies around the world looking for mechanisms to circumvent the statute. Some of those mechanisms are aggressive and even dangerous, but can also be made entirely unnecessary if we just modernize the law. First, applying well-established rules of statutory interpretation, the Second Circuit Court of Appeals last year held that warrants issued under ECPA cannot compel service providers to search for, seize, and produce data that is stored outside the United States. This, of course, has presented challenges to law enforcement, as you have heard from the Department of Justice. Other cases pending around the country that raise the same issues have judges working to understand what Congress intended in the statute that was enacted well before providers like Google and Facebook even existed. Courts are being asked to resolve these disputes in ways that are divorced from sound policy solutions, without the opportunity for robust debate among the stakeholders, and indeed potentially entirely enclosed courtrooms. This is hardly the path for appropriately addressing the equities of users, law enforcement agencies, service providers, and addressing international comedy. The source of all of this is a statute that needs to be updated to reflect the technical, business, and other realities of our time. Second, ECPA includes a broad so-called blocking provision that restricts the circumstances in which U.S. service providers may disclose the content of users' communications to government agencies outside the United States. There are legitimate reasons that a country may wish to control how and to whom data can be disclosed, for example, to prevent disclosure of information to countries with poor human rights records. A broad blocking statute that is divorced from these sorts of concerns and lacking nuance, however, can leave governments that have a legitimate need for information looking for alternative means of acquisition that unnecessarily redound to the detriment of users' privacy and civil liberties. The blocking provision in ECPA is a source of enormous frustration for democratic countries that respect the rule of law and maintain robust substantive and procedural protections of civil liberties. These countries may be unable to obtain timely access to digital evidence solely because it's retained by a U.S. service provider subject to ECPA, even for crimes that are wholly domestic in nature. The inability to obtain this data creates incentives for these countries to seek other unilateral techniques to get the information, including enforcement of their surveillance laws extraterritorially, even in the face of conflicting U.S. law. It also creates incentives for enactment of data localization laws and aggressive investigation efforts that can undermine security in general. It's quite clear that the status quo is unsustainable as technology evolves and has flourished, and services offered by the U.S. internet companies are being used by people outside the U.S. Key assumptions around ECPA are obsolete. Congress should holistically modernize ECPA to address the many challenges that have emerged in recent years. We respectfully recommend that an effort to update ECPA include the following three changes. First, require government entities in the U.S. to obtain a search warrant to compel the production of communications content from providers. Second, provide clear mechanisms for the U.S. government to obtain user data from service providers wherever the data may be stored, but with protections built in for certain cases when the U.S. government seeks contents of users who are nationals of other countries or located abroad. Third, lift the blocking provision in ECPA to permit U.S. providers to disclose data to certain foreign governments in response to appropriate legal process in serious cases when the domestic laws of those foreign countries provide baseline privacy, due process, and human rights guarantees. There is no panacea for the range of challenges presented by aging legal regimes, but we believe that these three steps ensure that ECPA's foundational construction is on the basis of sound policy principles that reflect the equity of users, law enforcement, service providers, and international comity. Thank you for your time, and I'd be happy to answer questions.
Chair now recognizes Mr. Littlehill.
Mr. Chairman, recommended commoners, members of the committee, thank you for inviting me to testify. I'm a technical investigator in Tennessee, and I chair the Technology and Digital Evidence Committee of the Association of State Criminal Investigative Agencies. For more than 20 years, I've helped criminal investigators obtain and use communications records for use in both technical investigations like internet crimes against children and cyber cases, and in the range of other criminal cases that we support. My community faces a range of barriers that impede our lawful access to digital evidence, and the problem is growing as mobile apps and internet-connected devices proliferate. We're told it's a golden age of surveillance, but those of us in the trenches doing investigations and protecting the public see things differently, as we're turned away empty-handed from one source of critical evidence after another. The challenge that brings us here today is the Second Circuit's Microsoft Ireland decision, which is a growing problem for the state and local law enforcement community. Despite grave concerns expressed by concurring and dissenting judges, despite district court judges in 5 other circuits who've declined to follow the ruling, many tech companies continue to apply the standard across the board and reject legal demands everywhere in the U.S., creating another blind spot in state and local law enforcement's ability to access digital evidence. Let me give a couple of examples to show you why this practice is so frustrating for us. In testimony before the Senate Judiciary Committee last month, one of my peers from Massachusetts described a California case involving the disappearance and suspected murder of a young girl. The investigators developed information that the contents of an account maintained with a cloud service provider could help them determine what happened to the girl and where to look for additional evidence. A court agreed and issued a search warrant. The service provider objected to the production of any content stored outside the U.S., which, according to the investigators, included the categories of records most likely to be useful in that case. A second example comes from the state of Mississippi. A service provider advised the National Center for Missing and Exploited Children that an unknown party had uploaded child exploitation images to a cloud account. The investigator who got the case from NCMEC sought a search warrant for the contents of the account. While waiting for the service provider to respond, the investigator was able to identify and confront a suspect who confessed that it was his practice to meet people online and share child pornography images in order to receive similar images in return. When asked whether he received any pictures that made him think the senders were actively molesting children, he stated he didn't know, but that he was talking with, quote, some very bad people. The investigator received a foreign evidence denial as to some of the requested account contents, and though everything points to the suspect accessing the account from within Mississippi, the investigator sent 2 further requests for information on how to obtain the content that might lead to unknown minor victims. As of yesterday, the investigator has not received a response. When investigators face foreign evidence denials like these, their only option is to pursue the mutual legal assistance treaty process, which is widely regarded in the law enforcement community as too cumbersome to be effective. Delays run from many months to years. This simply does not allow investigators to obtain the evidence that they need in a time frame that's useful. All of that assumes, of course, that the service provider tells the agency what country to direct the MLAT to, which doesn't always happen. Everyone agrees that this situation is problematic. Evidence that can help solve crimes committed in the U.S. by people in the U.S. against victims in the U.S. is often unavailable even after a judge signs an appropriate legal demand. In Judge Lynch's concurrence to the Microsoft Ireland panel decision, he writes, quote, without any illusion that the result should be regarded as a rational policy outcome, let alone celebrated as a milestone in protecting privacy. We agree, and we hope that Congress can take quick action, carefully weighing public safety needs alongside the business interests of providers and the privacy concerns of their customers. Public safety should not be an afterthought or side issue as technology advances. My peers and I are eager to help where we can in collaboration with our federal partners. To wrap up, Mr. Chairman, state and local law enforcement investigators see this issue of evidence stored abroad as part of a broader policy challenge, which includes, among other things, the lack of a legal framework around service provider response to legal demands, data retention, and a lack of good information about what evidence is even available on service provider networks. We agree that laws intended to provide law enforcement access to digital evidence like ECPA and CALIA need to be updated to make sense in the 21st century, but those updates must be balanced to address the very real needs of the law enforcement community and crime victims to avoid unnecessary barriers to investigations. We greatly appreciate this committee's ongoing solicitation of our input, and I look forward to your questions.
Thanks, sir. Mr. Calabrese.
Thank you. Chairman Goodlatte, Ranking Member Conyers, members of the committee. First, let me just say how happy I am to see everyone here safe and sound after yesterday's tragic events. Our thoughts and prayers go out to the victims, but I'm just glad to see so many friendly faces here, safe and well. Thank you. We appreciate the opportunity to testify on behalf of the Center for Democracy and Technology. CDT is a nonpartisan advocacy organization dedicated to protecting privacy, free speech, and innovation online. We applaud the committee for holding this hearing today. There is no question that the system for sharing information across borders is in need of reform. Law enforcement is correct that it is slow and sometimes frustrating. U.S. service providers rightly worry about being caught up in a conflict of laws. However, it's worth noting the system does have benefits. The most notable is that in many cases, citizens around the world are protected by the strong privacy guarantees of the U.S. Constitution, specifically the warrant requirement of the Fourth Amendment. We must not lose that commitment to privacy even as we reform the broken elements of the system. CDT believes the best way to achieve reform is through a package of legislative changes, specifically passage of the Email Privacy Act, adoption of a structure for privacy-protective bilateral agreements, mutual legal assistance treaty reform, and enactment of a version of the International Communications Privacy Act, ICPA. First, Congress must set a privacy baseline in the U.S. in U.S. law by passing the Email Privacy Act. This committee is intimately familiar with this bill, having stewarded it through unanimous House passage over the last 2 Congresses. While the warrant for content is generally assumed to be the default, including by the Department of Justice in its testimony today, as the committee knows, that's not what ECPA says. Because the law was passed in 1986 and has not been substantially updated since, in many cases it authorizes access to content with the use of a simple subpoena with notice. Service providers are to be commended for insisting on a warrant pursuant to the Sixth Circuit decision in Warshak, and DOJ has stated that seeking a warrant is their policy in criminal cases. But appellate court decisions and department policies are not a substitute for federal statutory reform. Second, once we have a baseline in U.S. law, we must extend it to other rights respecting nations through a strong privacy protective framework of bilateral agreements between nations. These agreements would be safety valves, allowing speedy access for law enforcement, reducing conflicts of law, and reducing pressure on the MLAT system. The Department of Justice has made a good start in laying out such a framework. There are, however, important areas where it must improve, including how the proposal handles which nations will qualify as partners, enhancements to legal standards for accessing information, and limitations on privacy-invasive techniques like the use of metadata and wiretapping. With these improvements, bilateral agreements can speed law enforcement access, respect national law, and improve privacy. Third, since not every nation will qualify for a bilateral agreement, Congress should reform the existing MLAT process. ICPA contains important reforms that should be adopted to speed the process. In addition, the European Union is developing materials to educate their local law enforcement on how to best meet the U.S. probable cause standard. Those materials can be and should be used globally. Finally, any proposal should include the principles embodied in ICPA when U.S. law enforcement seeks to access communications. ICPA rightly moves away from the use of location of data as a standard and towards the nationality of individuals under investigation. It also respects the interests of other nations by deferring to them in cases where MLAT agreements are in place. This framework is not perfect. Specifically, it may result in the adoption of extraterritorial warrants by other nations or unintentionally allow some nations to slow investigations. CDT is happy to work with the committee to address these concerns and is encouraged by the number of positive ideas already under discussion, including a mandatory comedy analysis by courts and reciprocal notice and control provisions for other nations. While none of these solutions will be enough on their own, CDT believes that collectively they can safeguard international comedy, assist law enforcement, and most importantly, protect individual privacy.
Thank you, sir. Now, Professor Woods.
Thank you. Chairman Goodlatte, Ranking Member Conyers, members of the committee, thank you for inviting me to testify here today. ECPA is the single leading cause of conflicts of laws in the tech world today. So I'm grateful the committee has shown great leadership in this context. The good news is that this is actually a pretty easy problem to fix. ECPA operates, as you've heard, as a blocking statute, standing in the way of American tech firms' compliance with lawful government requests for data, both here and abroad. Remove those blocking features, and you solve the bulk of the problem. Now, this means two things. First, reverse the Second Circuit's recent decision so that a production order under ECPA can compel a U.S. firm to comply, regardless of where they choose to store their data. And second, allow U.S. firms to voluntarily comply with foreign law enforcement requests wherever they choose to operate. On this second point, I actually think the solution may be simpler than DOJ has made it out to be. You need not specify which countries can enforce their laws against American tech firms, nor the conditions under which they do so. I used to think that was a really good idea. After all, if you care about privacy, surely you'd want to clarify how and when, which foreign governments can access internet content. But I'm less sure about the wisdom of telling other countries how to behave today. You don't tell Citibank and Costco under what conditions they can comply with British law. Why tell Google and Microsoft? Indeed, if you were to propose to make it harder for American banks or America's retailers to do business in other countries, you would likely never hear the end of it. Not only does blocking foreign government interests make them mad, with all of the attendant diplomatic fallout, but I believe it makes the internet less secure. When countries can't enforce their laws, they do a number of unfortunate things, and in particular three. First, they make it hard on U.S. businesses, arresting their employees, increasing operating costs, often by demanding that data be stored locally. Two, they increase their efforts at surveillance, often without court supervision. And three, they threaten to retaliate against the United States by imposing their own ECPA-like blocking statutes. This last point is an underappreciated one. In a not too distant future, many Americans, perhaps most, will be running around with a foreign-made app on their phones. In the wake of some crime, American law enforcement will seek access to data held by the foreign app maker doing business here in the US. If the app maker is from a country that has a blocking statute like ECPA, or a country that is excluded from the bilateral or multilateral club that DOJ has envisioned, our law enforcement agents will be in trouble. These foreign government reactions to our blocking statute are unfortunate, but they are also understandable. Indeed, it is partly American law enforcement's own frustration here that has led them to call for backdoors on encrypted services, the unregulated use of stingrays, and other desperate and, in my view, foolish measures. When I speak to prosecutors in Brazil and India and France, they ask one question: why should we need to follow American rules in order to enforce our own laws on our own soil? The answer, of course, is that they shouldn't. The lodestar of conflicts of laws has always been the respect for sovereign interests, and if we craft a regime that does not do that, I fear we will regret it. So to briefly summarize, ECPA is easy to fix at home and abroad. The location of data should not matter. Rather, the location of the investigation should. Except in extreme circumstances, if a service provider is physically present in a jurisdiction, providing services, making money there, they should be in a position to respond to lawful and legitimate law enforcement requests. That's true here, and that's true abroad. This is the position nearly every other American company finds itself in, and tech firms should be no different. To make this a reality, you need to reverse the Second Circuit's decision, and you need to lift ECPA's blocking features. Now, I just want to emphasize that I say this as someone who cares deeply about privacy and security on the internet. In my view, the only way to secure the future of a global internet is to provide room for governance differences around the world. Either the laws bend or the technology will be bent and broken. Keep in mind, we're not talking today about the hard stuff, like warrantless surveillance, state efforts to weaken encryption, or forced data localization. Rather, we're talking about a simple step that you can take today to prevent those things. Thank you very much for your time, and I look forward to your questions.
Thank you, Professor Woods. I'll start the questioning here as we go. Ms. Delgado, I have a question. How urgent, and from your perspective, how urgent is this problem? And are we talking only a handful of countries here that are enacting data production and data localization requirements? What are the impact, if you can quickly sort of answer that, the impact of these laws?
Thank you for the question. I think it is quite urgent. The two issues that we're talking about here, both the blocking statute question about the ability to comply with requests outside the United States, as well as being able to produce data that's stored outside the United States to U.S. authorities. Both of those are urgent matters. They're threats to public safety. They're threats to American companies.
Okay. And also, then it's been talked about a little bit here. Some have argued that it should be nationality or location of the customer determines the country's law, which one controls. Sort of a two-part question. One, is Google able to definitively determine the location of a customer? And number two, are they able to definitively determine the nationality of a customer?
The answer is no. We very unlikely we'd be able to be determinative. We may have information that could inform a court that needs to decide whether notice, if that's the approach we're taking, it needs to be given to the other jurisdiction. So a provider may have relevant information to help inform a decision like that. Law enforcement itself should probably bear the burden of being able to establish that they've at least gone through the steps to try to determine the location of the user, to determine whether they are excused from other requirements.
And in some ways, wouldn't the nationality actually be a slippery slope question for a tech company or even frankly, even law enforcement there, unless there's, definitive kind of answers to that question?
There needs to be a standard. It may be that the standard isn't definitive. It's something less than that there's credible evidence. There's a whole list of possible standards. Preponderance, it could be,
okay.
You're right, from mere evidence all the way to the full, more likely than not. So that would be an issue for debate to come up with what's the right level.
Great, well, I'll come back in just a second. Professor Woods, what kind of reforms to the MLAT process do you believe should be made? These impacts do you think would improve the process we could have on international conflict of laws that are being discussed?
Yeah, so as I say, the easiest way to resolve this problem is to allow countries that operate globally to respond to lawful requests where they receive them. I would emphasize lawful. I agree with my colleagues here that we may be able to parse out some countries we think don't operate by the rule of law. But we want to be in a position where the MLAT system, which needs to be reformed in a number of ways, and I've got ideas about how to do that, happy to speak to that, but the MLAT system, it should not be the place where cross-border data requests are made. It's just not built for that.
Okay, granted with that, and there's a lot more, again, this is not a small subject we can discuss, but I do have a specific maybe on this. What effect does data localization laws have on U.S. national security, the ability of U.S. intelligence community to collect necessary intelligence to protect the homeland? Can you answer that maybe briefly?
In my understanding is that it is considerably harder for U.S. law enforcement to get access to data when it is stored under a forced localization mandate abroad.
Okay. All right. One question, we've had this before, Ms. Littlehale's been here before, and we've had questions, but I do want to go back, and I believe the balance of law enforcement and the needs here. But in most of the examples, which of course would be the problems, Ms. Delgado, do you think that every example on a negative highlight that was given is where tech was not cooperating? I'd like to at least hear the other side, because we've heard this before. Tech does cooperate with law enforcement, correct?
Well, certainly speaking for Google, the rules are generally pretty clear about what it is we're required to do and what the legal process should look like, and it works pretty well. There's emergency situations where the law enforcement may not have time to go through legal process. We respond to those to save lives and to prevent physical injury when needed. I think in general the ecosystem works pretty well. The statute, though, is pretty aged at this point, and it's no longer reflecting what's really happening. And the result of that is that law enforcement's getting frustrated because of interpretations like what we saw out of the Second Circuit. And other jurisdictions are having to adopt to the limitations they're facing under U.S. law by engaging in sometimes unsavory techniques to try to be able to get the information.
So really, from your perspective, at the end of the day, you may have differences of opinion on what, in protection of privacy from your business model and other standpoints, but at the end of the day, your company in particular, but other tech companies as well who are dealing in this, are more than willing to find a solution here that protects not only privacy of business interests, but also the needs of our security and our law enforcement.
Absolutely right, and in fact, this is a situation where I think we can, with these changes, recommendations we've made today, we can actually increase privacy protections and enhance law enforcement access.
Right,
To the
so any broad sweeping discussion, that is the more true answer, and there are exceptions to everything, but I think we're moving forward on an answer, and that's a good part. With that, I am honored to turn over the questioning to my dear friend, the ranking member of this full committee, Mr. John Conyers.
Thank you, sir, and I appreciate the witnesses and their differing views, but let me start with Mr. Calabrese, please. Sir, in your view, what are the shortcomings of the administration's proposed criteria for admission into the bilateral framework?
Thank you, Mr. Conyers. So I think there are four. The first is the way the inclusion in the club is handled. So first of all, we shouldn't have factors to consider. We should have mandatory standards that have to be met. And we should also have a better process for lifting up the factual basis for making that determination, an APA-type process, so we can get facts for whether you meet particular standards. The second is improvements to how we handle metadata. Obviously, this is incredibly sensitive information, and ECPA currently allows the voluntary sharing of metadata, and I think we need to, voluntary with foreign countries, and I think we need to address that. The third is I think we need a bar on wiretapping. Wiretapping is among the most sensitive types of invasion we have in our legal system, and I don't think we should allow it willy-nilly to be done by foreign governments, almost certainly at a lower standard. And finally, we need to look closely at the substantive standards and procedural requirements put in place by the bilateral agreement and look to raise them to be closer to a probable cause standard.
Thank you, sir. Let me ask you, in your opinion, must we hold other nations to our Fourth Amendment standard for access to content? For example, a warrant based on probable cause, even if that standard is wholly foreign to legal systems that on the whole have decent privacy regimes?
It's a very fair question. I think the first thing we should do is hold ourselves, of course, to the probable cause standard and pass the Email Privacy Act. The second thing, I think what we need to look for is comparable legal regimes, comparable legal standards. We're not going to get, and I don't think we should insist on foreign governments having exactly the same rules we have. They need to be comparable privacy standards. They need to be, they need to meet international norms such as human rights standards. And if we can get that kind of normalization with our key allies, I think we'll have real privacy improvements.
Anyone want to add anything to that? Yes, sir.
It's a great question, and when I've looked at the burdens on the MLAT system, there are at least two distinct kinds of burdens. One is that foreign countries say, why should we have to go through this process and make the request to the United States, let alone just solve it here domestically in our courts? If it's a Brazilian murder, a Brazilian crime, Brazilian victim, everything happens in Rio, why are we contacting the US? That's crazy, right? Separate from that, wherever the request happens, whether it's international or not, there's a resentment of having to use an American standard. And I fear that if we adopt a regime that relies, as you say, on an American standard like the Fourth Amendment standard, although it is the gold standard, we will incentivize states who resent being left out of the club or being forced to bow to that American standard, that they will do things like find ways to enforce their laws without our permission, and every single one of those possible ways to do that is worse than us negotiating a reasonable way for them to get lawful access to data.
Thank you. Mr. Salgado, has the Microsoft decision changed how your company responds to the government's demands for information under the Stored Communications Act?
Yes, sir, it certainly has. As I think the chairman said in the opening comments, the Second Circuit pointed out that there's a problem in the statute that really until then hadn't been pointed out, and that is that it appears that the statute does not cover data that's outside the United States and not in the United States, or that the warrant requirement does not reach that far. As a result, that means that the warrants we receive actually aren't effective to reach the data that's stored outside the United States, and as a result, we don't produce that data in response to those warrants.
Thank you, Mr. Chairman.
Thank you for that, Ranking Member. Now, the Chair now recognizes Mr. Moreno, and just for the sake of the committee, after Mr. Moreno's question, because votes have been called, we will be adjourning given the light of the situation the rest of the day. So, Mr. Moreno, your line of questions.
Thank you. I'm going to cut right to the chase. First of all, without objection, I would like to introduce into the record the testimony of Microsoft's Chief Legal Officer, Brad Smith, from the Senate Judiciary Committee's hearing on this same topic from May 10th, 2017.
No objections to order.
Thank you. Excuse me. Thank you for being here. Are you familiar with my legislation from over the last 2 years, the LEADS Act? Give me your opinion, because the LEADS Act simply delves into, Ms. Nelbene and I, from across the aisle, put this together, and it just puts together a legal framework for U.S. law agencies to acquire evidence from overseas. I always think something needs to be tweaked, but can each of you take a couple of seconds and address the LEADS Act and what might have to be added or taken out? Because I'm a law enforcement guy, but I do like the idea that we have agreed, so far I think we have agreed, that business, Congress, and law enforcement have to sit down and work this out, and there's got to be give and take on each side. And from a law enforcement perspective, I've been in situations where children have been kidnapped. As a prosecutor, we know that we have to have evidence almost immediately or else within 48 hours because the chances of retrieving them after that are very small. And we can't be in a position where we're waiting for to argue an issue brought before a court saying why we should or should not respond to something. So could you please respond to that array of questions?
I guess we'll start on this end. Yes, I think there is an agreement here that we need to do something, that we're in an untenable situation, all the stakeholders here, and I would include the courts in that. I think that the solution, though, is not in a statutory change that doubles down on location of data. I think we need to change the focus of the limits of the warrant requirement to the user rather than where the user's data is located. And hence the recommendation that we make, which is let's change the statute to reflect where the user is or where the user is a national, and focus on those equities rather than, in the case of Google, where the intelligent modern network has selected to store the data for some period of time.
Okay, anyone else care to respond?
Yeah, thank you. First of all, thank you. You clearly started an important debate with your legislation that is ongoing today, and I think we're getting closer to a solution. And it's a good piece of legislation. I mean, there were a couple of things I think concerned CDT. One was the one that Rick just mentioned, which is sort of you worry about embedding a technical solution or interfering with how a technical outcome would happen within an industry's systems with a legal standard. I think the second one, and one that CDT is worried about, is potentially the impetus towards encouraging other countries to engage in extraterritorial warrants. And I think that's one of the reasons we've talked so much about bilateral agreements. I think they're a nice safety valve in this same context, right? Because they say, that's fine. We want to give you the same deal that we have here, and here's how you do it. Here's the whole process. And I think that's an important safety valve, and I think obviously clearly be coupled with the work that you're already doing.
We have to respect other countries' laws, but we cannot be put in a position where those laws are so in opposite in law enforcement to what ours are.
Just want to echo Chris's point that you were at the forefront in starting to look at this with the LEADS Act, and I was excited when it was announced.
I've got to give my staff credit for that. They're pretty much the brains of the outfit.
I also want to echo Rick's concern about having anything turn on the location of the data. I think at the end of the day, the old school principles of jurisdiction ought to apply, and that is to say, I think consistent with what you were saying, legitimate state interests. When the United States has a legitimate interest in resolving a crime that has happened here in the United States, if a business is here in the United States doing business, making money, availing itself of this forum, it ought to be responsive to law enforcement investigations. That's not about where they store their data. That's about where they operate and where the crime occurs.
I would just very quickly point out that from our perspective, the real challenge comes in looking at reform in the area of all of these statutes, where we are going to get the information in order to make the demonstrations that we're required to about where the particular, either the data is or the person is, nationality and so forth. Very often in a time-sensitive environment, we are dealing with a limited pool of information where we can get information because, as was pointed out earlier in the hearing, we don't have the ability to go out and gather that evidence ourselves. We're dependent on what we can get by service of legal demands. So I think any effort to look at that must take that set of realities into account, and we look forward to the conversation.
Thank you for that. This concludes today's hearing. Thanks to all the witnesses for attending and sitting through what has been a longer hearing. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses and additional materials for the record. With that, the hearing is now adjourned.
Get it out. Yeah. That was a good deal.